Yes, sir.
Adjournment request, if any, from item number 1 to 15.
You have circulated the adjournment slip. All right. Have you yes, but these are all IAs. Have you informed the lawyers for the other analogous matters?
All are either.
So we are adjourning it for give a date, consensus date. 12th of May. All right. But you don't decide the date yourself. You give a proposal. It is for the court to accept according to the calendar of the court. Let's see on that date. We'll see.
12 May.
Yes. He is standing by your side.
Want to engage.
You have a right to engage, you engage. But Mr. Roy Chaudhary, your research we will take into account. You have done it for ours. You have done it for our convenience. So you please hand it over to us. All right.
Next date may be given, Madam.
April.
No,
As prayed for by Sri Subhash Kumar, petitioner in person, the matter is adjourned to sometimes in April.
Madam, 6 April,
Sometimes in April, we said, he is giving you the date.
20th April, 20.
So my name may be reflected.
we can assist the-
For this
because
matter.
you-
No, you do one thing. We will not put you to that discomfiture where he has chosen another advocate. You just do one thing. Anytime over the day, once you prepare it, you hand it over to Mr. And we shall have you summoned. Why should your name be here if he's not ready?
It would
to
have
take
been a
his-
pleasure for myself to place my submissions.
All right. So we will, you do it and we will call you. Whenever we will remember it, we will call you.
28th April.
20th.
20th.
20th of April.
20. All right.
But you can give your research to the court
But
master
in the meantime, I will draft up.
at your leisure, at your convenience before the date. And then we will have you, we will request you to be here on that day
Definitely.
as our advocate.
It is my pleasure to play.
Obliged, Madam.
May I please your lordship, sir, regarding item 11 and 15, we seek adjournment today. Sir, as my learned senior advocate is out of station.
All right.
Thank you.
On account of adjournment slip has already been circulated on account of unavailability of the advocate who is to address this court. Stop. Re-notify, give a date.
29th April.
Alag order likhna.
Both the cases continue. Item 16 to 28, adjournment request.
May I please your lordship, on behalf of the appellant, I beg to mention item 28, my lord.
Item
28, and seeking an adjournment.
Adjournment slip has been
Circulated
circulated.
adjournment slip.
All right.
One prayer, my lord, matter pertains to my lord pension, retirement benefit. So my lord, may kindly fix it in second week of March, my lord.
Just see the calendar is.
31st March. 31st.
Have it on, have it in the last week of March. 31st of March.
And so obliged.
May I please proceed? Proceed, I beg to mention item number 17, my lord.
17 is that death sentence,
Yes,
death
my lord.
reference.
Due to some, my lord, medical emergency in my family, I could not prepare the same, my lord. That's why.
Adjournment slip has been circulated in the matter. As prayed for, re-notify. When do you want it?
10th March.
There is some urgency here.
My lord,
Urgency from our side,
My lord,
but that
yes,
will
my
not
lord.
keep these things
can it be
pending.
fixed on 10th?
10th March.
10th of March.
10th.
10th of March.
Obliged.
Obliged.
Lordship, yesterday we had mentioned 2, 3 matters. Your Lordship, one has come up, 2 did not come up, Lordship. May I plead a matter may come up along with item number 29 today itself.
That if that is defect free,
Lordship.
bring that matter,
Lordship.
if it is defect free.
My lord, I beg to mention an item for listing, my lord, a writ appeal, which was filed on 21st of February. May it be listed on 1st of
What
March.
is the urgency?
Urgency is the eviction matter, my lord,
When do you want it?
on Monday, my lord.
No,
1st of
Monday, next week. Monday is the first day. Sitting with- Monday is a special bench, we will not take it up.
October.
So it goes on after 9th of March.
Daily list for orders item 1.
Yes,
We have filed our affidavit in reply, but not in record, so my lord.
it,
We have filed our affidavit in reply, my lord. So my lord,
yeah.
no, my lord, it has not come in record.
What have you said in your affidavit?
Lordship, in our affidavit, Lordship, the contempt against the petition which was filed, Lordship, was in accordance with Mohar Ali Sheikh, Lordship. In Mohar Ali Sheikh, Lordship, a review has been filed, and in the review, an interim
The,
order has been passed, and no contempt lies.
Learned counsel for the petitioner submits that the rejoinder to the affidavit filed on behalf of the respondents, answering respondents, has been filed only recently, which has not been tagged with the records of this case. Let the rejoinder affidavit be placed on record and this case be listed for consideration. Sometimes in April.
Deeply obliged.
22nd April. Item 7.
No, item number 2 is left.
2 to 6, that is it.
2 to 6 is it. All right. Item number 7. Yes,
May I please your lordship, my lord? My lord, this appeal is preferred against the, my lord, judgment and my lord, order passed by honorable single judge.
give us a minute.
Matter relates to, my lord,
Just a minute, Mr. Prakash.
Mal.
Give us a minute.
my lord.
Yes.
My lord. Therefore, my lord, the honorable single judge, my lord,
Yes.
without taking into consideration our basic contention, our contention is twofold, my lord. Number one, my lord, my appointment was only against a personal post. Therefore, I don't
That's
have any
right. Personal post means
personal.
that, just a minute, Mr. Prakash.
My lord.
Personal post means that
I-
that post would vanish. It will not
Yes.
be there
My lord.
after you retire.
Yes, my lord.
That's right.
Postal
So,
advocate,
for the purposes, but that doesn't mean that you shall not be transferred.
number
That's for
one.
the administrative convenience.
My,
Now, the only ground which you can allege is that initially you were asked to show cause
my lord.
why you should not be transferred because there were complaints against
My
you.
lord.
Later, that affidavit was retracted perhaps.
There are number of complaints against me. my lord.
No, later the decision was for the administrative ease, for the purpose for which transfer could be made. And why, what business have you to contest that unnecessarily? You were posted there at your original place of posting for a long time.
No, my lord. Initially, my lord, they didn't say anything. Later on, my lord, they filed.
So why do we, which law has been breached in your transfer?
My,
A
my lord,
personal person holding a personal post
my lord.
is liable to be transferred for administrative convenience.
So unless and until post is transferred, my lord, I along with the post.
Show us any rule prescribing such transfers.
Secondly, my lord, my lord.
First you answer the
My-
first question. You
my-
come to the second point only later.
My lord.
Yes.
Then lordship may kindly, that question was not even examined by me. My lord, basically for the reason that, my lord, I thought that, my lord, my second ground will prevail.
What is your second ground?
Second ground is that, my lord, if the transfer is the outcome of, my lord, certain complaint.
That we said, it has been retracted. It
Yes,
was a
in the-
wrong usage of the word that because of the complaint. They say that it is necessary that you be transferred.
My lord,
All
looking-
your interests are protected. Go and, have you joined? When was the order of transfer?
No, I didn't join, my lord.
You did not join.
I didn't.
Your salary has been withheld.
My lord, with that.
You, possibly you'll have to quit the job.
Oh, lordship,
don't-
examine this question, my lord.
When was the transfer order passed?
Transfer order was on, my lord, annexure 2 at 15/6/2023,
So for all these years, you're not rendering your service.
my lord.
Huh?
Because, my lord,
And a casual worker.
I
Oh,
filed
yes,
representation.
Sorry,
Uh,
we don't find any reason.
My lord, I am a casual worker, my lord. Whether
Uh,
casual worker
So
can
we
be
don't
transferred.
find any reason to
Hello.
interfere with the judgment of the learned single judge, which runs
My
in
lord,
about
whether,
40
my lord,
pages, which was not necessary.
my lord, whether by transferring me as a casual worker, whether any administrative actions can be served.
In fact, the employer should have been more, some thinking should have gone into the decision making. They should have terminated your service.
My lord, they took a stand.
You
That
should have
way-
been discontinued.
No, they took a
What is this? Sorry, sir. Take down.
Lordship kindly appreciate, my lord. They took a stand that we want to transfer him,
See, normally we don't say this in the beginning of the argument,
my lord.
but don't press it further because we are inclined to even impose cost and ask for other administrative measures to be taken against you. That's what is our view tentatively. Don't insist for all such things. You're a casual laborer. Your services have you been regularized?
No, not regular.
No, you are regularized, and without regularization, a personal post could not have been created. What, Mr. Purkar?
No, my lord, casual, my lord, my lord, appointment, kindly look at the appointment letter.
No.
He's insisting in.
Take down.
Look at the appointment letter. I was appointed to office assistant on casual basis.
Be that as it may, but it was the post was personalized for you.
Personal to me.
You don't perform well.
And,
You
my lord,
create problems.
No, had I been regular,
Sorry.
had I been regular, my lord, I would have bought the regular scale. They are paying me only the fixed
No,
pay.
we are not inclined to interfere. Sorry. Heard Mr. Purkar, learned advocate for the appellant and so for the state. The appellant, a casual employee, appointed as an office assistant in the
My lord,
panchayat.
lordship, may I,
We are going to say that if you have not joined, further disciplinary action should be taken against you. You want that? Then don't press this. We dismiss it with reasons and then we also say that further action should be taken. You don't want it, just withdraw this appeal, go and join. We will not even say. We are not threatening anything,
My
but
lord.
this is our view which we must put it across to the council.
my lord.
What is this? What do you want? You want to withdraw or you want?
My lordship, may make an observation there so that I can go and join.
After some arguments, Mr. Purkar, learned advocate, seeks permission to withdraw this appeal. For the purposes of joining at the post at the place where he has been transferred. We may indicate here that the transfer order was passed in the year 2023. Until date, the appellant has not joined his place of posting on transfer. First up, perhaps for this reason, his salary also appears to have been withheld. First up, unless any other sequel administrative action has been taken against the appellant, the respondent authorities would consider allowing the appellant to join the transferred place of posting. With such observation, the appeal stands dismissed as withdrawn.
And my lord, so far my salary part is concerned,
That's a
observation-
separate cause of action.
My lord.
Item number 8.
Pass some judgment. We have decided this issue, no?
Yes, my lord, this has been
In
decided.
Lytton, Dev.
Lytton Das. Yes.
Lytton
That
Das.
is there.
Are you aware of it?
Yes, lordship.
Where is that judgment?
My lord, I have.
The same case.
Lordship, so far as
Can we go beyond this?
Lordship, so far as me is concerned, Lordship,
Yes.
I would like to place one judgment of the Supreme Court, Lordship. Regarding second provision, Lordship, it is latest judgment. There is embargo in our case. Para 32, Lordship. More specific. 32, Lordship.
Yes,
May I read, Lordship?
yes.
Whether a reserved candidate
No,
who
no.
has
In Sadhana Singh Dangi, the court again looked. Start from the beginning of the paragraph 30.
Yes.
Which paragraph are you referring?
32, Lordship.
32.
Yes,
No, you read 30 first.
30, yes.
You
In
are aware
Sadhana,
of this judgment.
yes, Lordship. In Sadhana Singh Dangi, the court again looked into migration of women candidates availing horizontal reservation from reserved, that is OBC category, to unreserved category. The recruitment process permitted migration in vertical reservation, but stated that the horizontal reservation for women in compartmentalized. Referring to the observation of Ravindra Bhatt in Saurav Jadhav, the bench reversed the decision of a high court bearing migration in horizontal category, observed as follows. It is true that the leading judgment in Saurav Jadhav considered the matter from a general plane.
All right, paragraph 32.
Yes, Lordship.
Whether?
Whether a reserved candidate who has availed relaxation of in fee of the upper limit in participate in open competition with general candidates may be recruited against unreserved seats would depend on the facts of each case. That is to say, in the event there is no embargo in the recruitment rules oblique employment notification, such reserved candidate who have scored higher than the last selected unreserved candidate shall be entitled to migrate and be recruited against unreserved seat. However, if an embargo is imposed under relevant recruitment rules, such reserved candidates shall not be permitted to migrate
Correct.
to general
It
category.
was the embargo under the Assam rules.
Yes, Lordship, that was only from reserved. Second proviso, Lordship. I'd like to place second proviso of the Assam rules.
Assam rules, they were. President.
Lordship, second proviso. Assam Act, Lordship.
Yes.
Second proviso, Lordship.
Of rule?
Rule
Rule
4. Act Section 4.
Section 4.
Yes, Lordship.
Yes.
Provided further.
Read the entire section.
Yes, Lordship. At the commencement of this Act, 30% of the vacancies in respect of all appointment to the services and posts in the establishment which are to be filled up by direct recruitment shall be reserved for the women candidate. Provided that the aforesaid reservation shall be inclusive of the reservation provided statutorily or otherwise to the scheduled caste, scheduled tribe hills, other backward classes, more other backward classes, and persons with disabilities within the respective reserved category. Provided further that 30% reservation of the vacancies in respect of women for the remaining unreserved category of candidates shall be available to the women of unreserved category only. My humble submission is that, Lordship, until and unless
Just a minute.
this law is struck off,
Just a
I
minute.
have a right.
Just a minute. Perhaps there is no need of striking off or reading it down. The explanation given with respect to unreserved is that it's open.
Open.
It is not reserved for anyone. That is perhaps the only.
Lordship, learned single judge has interpreted like that way,
And
but
the
it
di-
was
and
not the
divi-
issue.
And the division bench also has
Lordship,
agreed.
Lordship, it was not the issue, Lordship. The Assam Act was not the issue before learned single judge and here, Lordship. Because all others, Saurabh Jadhav and all others, that was interpreted in that way. It was an UP case, Saurabh Jadhav. There was no Women Reservation Act.
What's your name?
Darakullah, Lordship.
Huh?
Darakullah.
Mr. Swens, we have heard Mr. Swenso, learned advocate for the appellant, who has questioned the judgment dated. Was questioned the judgment dated. So passed by a learned single judge of this court, WPC number 1097 of 2025, which judgment has been sustained in writ appeal number 27 of 2026. The learned counsel for the appellant has submitted that the issue is required to be argued, namely the observations of the Supreme Court, Union of India and others versus Sajib Roy, 2025, 0 INSC 1084. In the aforenoted judgment, the Supreme Court, after referring to the case of Sadhana Singh Dangi versus so-and-so, give the citation also. It was held that the question whether a reserved candidate who has availed relaxation in fee / upper age limit to participate in open competition with general candidates may be recruited against unreserved seats would depend on the facts of each case. It was further explained that in the event of there being no embargo in the recruitment rules / employment notification, such reserved candidates who have scored higher than the last selected unreserved candidate shall be entitled to migrate and be recruited against unreserved seats. However, if an embargo is imposed under relevant recruitment rules, such reserved candidates shall not be permitted to migrate to the general category seats. In the present case, advertisement had been issued in August 2022 by the establishment of District and Sessions Judge Kachar Silchar for filling up 11 grade 4 posts. The select list was prepared one Litan Dev, bracket appellant in WA number 27 of 2026, was Litan Dev, appellant who belonged to unreserved category, fourth in the merit, and he was appointed and also joined his duty in the year 2024. after about 2 years, one Mitra Chakravarti, bracket Kanu, the appellant herein, Mitra Chakravarti, bracket Kanu, the appellant herein, preferred a writ petition before this court, alleging that 30% horizontal reservation for PWD and women candidates had not been computed properly in preparation of the select list. She had scored 74 marks, was ranked 19th in the merit list. Her claim, therefore, before the court was that she should have been appointed against one amongst the 4 posts meant for the unreserved category. This claim was made on the basis of the second proviso to section 4 of the Assam Women bracket Reservation of Vacancies in Services and Posts bracket close Act 2005. We have to extract the aforenoted section in its entirety for the sake of clarity and completeness. Act entire 4. All right. The learned single judge had rejected her contention on 2 grounds. But what had also weighed with the learned single judge was he had applied as a general category candidate. The entire select list was questioned by the learned single judge on the ground that the vertical reservation in favor of women was not computed appropriately. Thereafter, applying the principle, calculating the reserved seats for horizontal reservation. What did I say? As set out by Supreme Court in Rajesh Kumar Daria versus Rajasthan Public Service Commission and others, 2007, 8 SCC 785, Saurav Yadav and others versus State of Uttar Pradesh and others, 2021, 4 SCC 542, and Sadhna Singh Dangi and others versus Pinky Asati and others, Supra, उसका वो जहां ऊपर में लिखा है उसका citation लिखना 2022, 12 SCC 401. That the 4th place in the unreserved category was required to be given to the highest scorer amongst women, not necessarily of the reserved category, as unreserved category would be open to all and would not be limited to the candidates of the unreserved, only the candidates of the unreserved category, or women candidates of the unreserved category. Stop. Computing it by the aforenoted method, taking the unreserved category as an open category in which even persons of reserved category could fall depending upon their performance, comma, the London single judge directed for giving that post to, who was the lady who was given?
Samana Paul.
To one Sumona Paul.
Yes, sir.
To one Sumona Paul. Stop. Lytton Dev, therefore, had to go out of service. Lytton Dev, bracket appellant in WA number 27 of 2026, had to go out of service. Stop. Thereafter, in the reserved category, which candidate was given? No, no.
Rubina.
Rubina Nath.
She had got 73 only. Below me.
Ruby Nath or Rubina Nath? Ruby Nath, placed at serial number 74 in the merit list.
No, 21.
Placed at serial number
21.
21 in the merit list, was accommodated in the OBC category, in the reserved OBC category of women. First up. As noted above, the aforenoted judgment of the learned single judge stood affirmed in the writ appeal number 27 of 2026, in which the judgment was delivered on 19/2/2026. Now, let us see the Assam service rules, which is applicable apart from the reservation.
Reservation.
No, same, same reservation of women.
Service. These are, my lord, district of the establishment, my lord. The gate fee, there is no service fee.
What is the service rule?
Service rule, my lord, actually, these are the get employee, my lord, they are not ministerial service rule, but this is their establishment.
You have an occasion of judgment. Candidates shall
Never
be
know.
available to
Not
the women of unreserved category only. So, first off, there could have been some substance in the submission of the appellant herein, that the fourth post in the unreserved category have gone to the appellant who belong to the unreserved category. There were no placements amongst the first four posts meant for unreserved category, any woman candidate. But the disputed question now arises whether the appellant could have been taken to be a candidate of unreserved category. Could we take, she was unreserved?
Yes.
No, but you said you were,
No, I am unreserved.
no. But later you found that you claimed to belong to OBC category.
No,
No,
Lordship.
that he is not been.
Lordship, I had applied for.
Certificate was produced later on.
Lordship, I had.
Certificate was produced later.
क्या लिखा है?
I was considered as a general, Lordship. I had applied for general. I had submitted my OBC certificate later on. That was not accepted by the authority. I was considered as a general candidate, Lordship.
तो आप OBC से claim किया.
I was first among the first women, Lordship, among the general candidate.
Anyway, what did I say? But the disputed question, first, like here, Mr. Mohanta, learned counsel for the respondent. Number?
3, 4, my lord. 2, 4 and 5, my lord. 3, 4 and 5.
3, 4 and 5 shall respond to this, respond to this memo of appeal by the next date, by filing a detailed affidavit. Let this matter come up for consideration on so and so date. Why did you not notice? Are you, Mr. Mahanta, you have to say that this embargo is generally like
Embargo,
this.
my lord, unreserved, my lord, it means open to all, it is reserved for none.
That's all right, but then
But
the
that
new,
embargo is
the
intentionally list is
new
very clear.
judgment of the Supreme Court says that unless there is an embargo,
Embargo, my lord, the legislation intention is very clear, my lord.
interpretation all right, but the Supreme Court makes a distinction
My
here.
lord, that is judgment I have seen.
We had
Yes.
not seen
Lordship,
that.
thereafter, Lordship, thereafter also Supreme Court has passed judgment on this count, and Delhi High Court has also followed this Sanjeev Roy, Lordship.
But word unreserved itself, my lord, is in reserved for none.
We have followed that, but only taking
My lord,
from
I
that
understand.
reservation.
Only.
Respond, we'll see.
6 April,
Worth arguing.
6
In
April.
that case, if we agree to that, then we'll have to review our orders, judgment in the Litton Dev's case. Let's see.
No, at any cost, Litondas will out.
Litton does
He
otherwise.
is
accept.
otherwise, he will not come, my lord.
Yes, Lordship.
We will see, we'll see.
See, if we
All right,
see-
you respond.
Yes, my lord.
Obliged.
8 April, item 10,
But then it would amount to giving a go-by to the principle of unreserved.
Exactly, my lord.
An open.
It's a open means, my lord, open word itself says that it is open to all. It is reserved for none. Unreserved is not a
All right,
category.
yes. Your affidavit appropriately.
My lord, deeply appreciated.
Do some work, do some research work, give us all the judgments thereafter. Yes,
The appellants, my lord,
yes?
the appellants here in my lord,
Hmm.
number in 5, my lord. They have filed the petition for non-issuance of the appointment, my lord.
Or?
Non-issuance of the appointment, though they have been selected in PWD category.
Hmm.
Category.
Right.
The honorable single judge, my lord, very first day on motion day, my lord, without considering the rights and entitlements under the RPW Act 2016, my lord. And my lord, without going to the, my lord, the policy, my lord, in the RPW Act 2016 reservation policy. Right? The honorable single judge says,
Who's not appointed, selected over again PWD, appointment के time में they had some down.
So it was verified.
So it was verified
And it was found that that was a fraud. He did not
So therefore,
follow he did not get into that
the
benchmark.
if we have, does not have the benchmark. But the question is, my lord, the fraud does not comes in the RPW Act 2016, my lord. That was related judgment, my lord, which was passed in 1990.
Well, that Honorable Justice Arun Mishra's judgment.
My lord, and I have in review, my lord, I have placed a judgment, my lord, in re, my lord.
Very well, you respond, Mister.
My lord,
Fine, fraud initiates everything, that's fine. But if we knew technically, so this is not this. It's a coding itself, what's the certificate देना है? हम समझ
अगर certificate दे दिया, and if there is a doubt, they are going to go for re-verification. And if he doesn't follow,
appeal.
ठीक है, we will see.
Can it be a concern?
It is.
I'm saying legal. My view is just.
आज जवाब दे।
my lord, may I please? What?
That's one.
I'm sorry.
Lordship, only one submission I have to make at this initial say about the maintainability, because here Lordship 5-6 read petition initially and review 6 review.
Doesn't matter. We are not interested in all that. The issue
Because,
which has been raised, we'll see. Whether, see, there is a provision for appeal with respect to the benchmark,
Yes, ma'am.
right? So, and the code is also self-sufficient. Now, tentatively, our view is what the Supreme Court has said in that judgment, the detailed judgment, that fraud vitiates everything. So therefore, it would not be the presumption of the employer or the organization to just dub any decision as having been made because of fraud perpetrated on it. But then it can always go for re-verification. That's our view. But then let's see, they say that no. Why re-verification? It was done, that is by a statutory authority. And if you had any doubts, you could have appealed. You're the employer. You could have appealed that no, this benchmark on my verification, we have verified. Suppose somebody applies and the essential qualification is graduation. He brings a certificate, but you as an employer would be required to verify whether this degree is correct. To that extent, it is all right. But here, the disability, the benchmark disability has been decided by a statutory authority.
And certificate is issued.
So once you file, of course, it's difficult, we will always go.
Hmm.
Anyway, we'll see. Why have you referred to this visually impaired in judicial service
My lord,
case?
in this judgment, that indirect discrimination, the doctrine of indirect discrimination has been applied in respect of the PWD, my lord. In indirect discrimination here, my lord, if your lordship kindly see that judgment.
There is a power and they can do it. If they doubt for that.
And in test podcast, the burden is not before on us, my lord. After select list in the name of the select list, burden is upon the author estate, my lord, to say that the validity of the my lord OM, my lord. They have to, they are bound by the my lord, the rules which have the statutory force, my lord. So the OM, my lord, these OM, my lord, does not have the statutory force, my lord. The estate does not have does not have the power, my lord, to issue this OM, my lord, under the PWD Act, my lord.
कर सकता है ये प्रॉब्लम है उनके बेनिफिट ये प्रॉब्लम होता है कि दे आर नॉट ये मनाना है
You respond, we are framing the issues. You respond. But this cannot happen. Under the garb of some indirect discrimination, you can't possibly get appointment with your less than benchmark disability. But it is subject to argument. We'll see.
Yes, my lord.
Take down. The appellants participated in the state level recruitment commission recruitment process for 14,281 grade 4 posts in various Assam government departments. An advertisement issued in March 2022. The appellants claiming eligibility under the reserved category for persons with benchmark disabilities were selected and recommended on merit for appointment. When no appointment orders were issued to them, they preferred a writ petition before this court, which was disposed of by the bench which had heard the matter without expressing any opinion on the merits with a direction that the authorities would communicate the decision regarding each of the applicant's individual disability status and their claim and their subsequent claim and their resultant claim for appointment in writing. It appears that the appellants were communicated about their disability status, but
Not
the communication clearly implied that perhaps the appellants would be subjected to some form of re-verification or reassessment regarding their disability and whether they had crossed the benchmark stage. Thus, next paragraph. Thus, a fresh writ petition was filed. Thus, fresh writ petitions were filed challenging inaction on the part of the respondents in appointing the appellants. The contention of the appellants is that such writ petitions were dismissed at the motion stage itself on the judgment of the Supreme Court in state of Uttar Pradesh and others versus Ravinder Kumar Sharma and others 2016 for SCC 791, which dealt with fraudulent disability certificates under the old 1995 PWD Act and simultaneously upholding the validity of the application of Assam Government's Office Memorandum 2022 permitting re-verification of disability certificates, including reassessment of the percentage of disability by authorities like Medical Board at Gauhati Medical College Hospital, it was thus held by the learned single judge that if verification showed disability below the 40% benchmark, the appellants would not be entitled to the reservation benefits This was challenged by the appellants, but later withdrawn with the liberty to prefer review petition before the learned single judge. The review also was dismissed for not having dismissed for the reason of the appellants attempting at rehearing of the case on the same set of facts and law. The present appeal thus questions the opinion of the learned single judge based on the application of the ratio of state of Uttar Pradesh versus Ravinder Kumar Sharma Supra, which actually involved fraud under the repealed 1995 Act, which involved fraud under the repealed 1995 Act to the facts of the present case, which should have been governed by the provisions contained in Rights of Persons with Disabilities Act 2016. A question therefore has been raised in this appeal whether the Assam government's OM of 2022 permitting reassessment and re-verification of disability percentage, which could potentially alter the eligibility post-selection. a further question has been raised whether such decision would be in teeth of the provisions contained under section 34 and 101 of the Act of 2016, Central Act. The appellants have also attempted to argue that such re-verification for altering the disability bench, which could alter the disability benchmark, was in fact
Indirect.
is in fact an attempt at changing the rule of the recruitment after the selection has been effected. A reference has also been made by the appellant to the judgment of the Supreme Court in recruitment of visibly impaired in judicial service 2025 for SCR 2222. Guarding against discrimination through backdoor. So what is your name?
Lordship, I am appearing for respondent number 6, B. Chaudhary.
Mr. B. Chaudhary, learned advocate for respondent number 6, shall respond by filing a requisite affidavit by the next date.
Lordship, our responsibility as a commission is only to make the recruitment.
You respond.
No,
Here, are we asking you to issue appointment letters?
no, Lordship, appointment letters are not
Respond.
issued by the state
And
government.
state also shall respond.
By the
Yes, sir.
state government.
They,
this is
just a
so.
minute. Notice to respond number 6 is accepted by Mr. B. Chaudhary, who shall respond to this petition. The notice to other respondents is accepted by so-and-so, who shall also file their affidavits, who shall also file their requisite affidavits by the next date.
My lord, similar matters, my lord, the series of matter are pending before the honor court. Because of this, my lord, impugned judgment, my lord, that series or other cases are not being, my lord.
Doesn't matter. So we don't decide it today because the view, we hold a different view. Let's see. There is some distinction which we can draw, but let us see. Let us hear from them. Don't be in a hurry.
Fine.
At any stage, but there are many service jurisprudence. PWD is all right, but suppose somebody has some problem in the earlobes. Can he come and say that he has touched 40% benchmark and get appointment? Would that not be against the rights of able-bodied persons who apply in open competition?
My lord,
If you are disabled, if you are entitled for that reservation, absolutely no difficulty.
my lord, interpretation is required. That interpretation.
How long? See, it was the interpretation. We'll
My-
see. For how long it was kept pending, or whether you were appointment letters issued, and after 10 years, if they do it, perhaps we will not do it. After 2 years also, if they do it, that will not be permissible. But here, the appointment letters were never issued to you. Before it could be issued, it was verified that you don't meet the benchmark standards. Now, can that be the reverse discrimination? We'll see.
My lord,
We'll see.
let's see the act, my lord.
We'll see the
My
act.
lord, obliged.
I'm ready. We are open. This is the tentative view. We are open for it. We will hear your arguments.
My-
30th April. Item 12, trees appeal.
Which date have you given? It will be an interesting. Huh?
Copy report দিব আমার excuse me copy report দিব respondent মানে
My lord, in this matter, lordships, I was directed to file an affidavit. My lord, the affidavit is ready for swearing. My lord, I'm translating the documents that need to be annexed to it.
As prayed for by Sumitra Sharma.
Sumitra Sharma.
Sumitra.
SUMITR.
I remember the name of my colleague.
Yes, my lord, I haven't-
Sumitra Sharma. Land Council for the State. The matter is adjourned to after 1 week.
After 1 week. Deeply obliged, lordship.
Sixteen March. Item 13.
Same.
May I please, Lordship? Your Lordship, here, being a security, we have obtained a DM order.
It's all right. You have obtained the DM order, but they are not actually facilitating.
Yes, my lord.
All right. You
Lordship.
report.
Lordship, CO has.
File your affidavit.
Lordship.
You say that those
accept.
26 items boxes have not been ticked properly. MS Bora to respond to the petition. पूरा detail में लिखना ना.
Obliged.
10 April 30. Item 14.
Mr. Counsel, do we tell you something? I just saw you coming to that stage with a big thick file being handled by a lady. The file is always the ornament of an advocate. Now you coming later, the lady carrying the thick file, that did not appear good to me. Huh? All right, this is for you to think. I think I have made myself clear to you. No, you haven't followed what did I say. Anyway, forget it. Yes, argue.
Yes, it relates to family pension.
That's
My husband was an.
right. You want posthumous regularization. The government, the respondents also wanted. Mr. Nayak, what do you have to say? He is a work charged employee. He was.
Lordship.
He died. You realize the mistake. You also wrote for, regularization posthumously. So far, so good. Now, do you want to take a rigid stand? My brother has the entire details of, cases where interference has been made, especially here, when 30 years he has served and no pension.
Yes, Lord.
What do you have to say?
Lordship, so far as the issue is
The
concerned.
basic rule is that they have not, the husband had not been regularized and therefore no pension.
Yes.
But look at this. He is not a temporary employee. He is a work charged employee. Work charged employee in the sense that it was a permanent appointment. He worked for 30 years, transferred, everything was being given to him.
So far as
All scale, everything. It was not a fixed remuneration.
So far as my understanding is concerned, Lordship, in the state of.
No, your understanding technically is correct.
Yes.
Now, whether would you like to take a view in this case? Your understanding is correct. It's a one-line understanding, one-line reasoning that without regularization, the person is dead. The person is dead. We can't sort of.
In fact, that is the law settled by the Supreme Court.
इसको देखो निकल रहता है ना इसको हियरिंग करना है मुझे इसको हियरिंग करना है हियरिंग आज तो हियरिंग है हियरिंग करके तो जजमेंट हो रहा है आराम से लिखिएगा इसका इस केस में लीजिएगा लेकिन इसको ओपन करेंगे यस
To that effect, Lordship, I am placing 4 judgments. One is Uttar Haryana Bijli Vitran Nigam that your Lordship has already took note of in your Lordship judgment in the full bench judgment. Second one is Bujala Nagari Lordship. This is a division bench judgment. Series of judgments are there. So for our High Court is.
Upen Das also.
Upen Das is there. Upen Das is there. If not regularized, no consequential benefit like bench. Paragraph 20. Another judgment is there. Sunita Alexis, my lord, that's the Samrasul Lordship. This is 2023.
Can you do for this? I mean, let us not review the entire judgment and see this. Now we wish to make some adjustments for this, in this particular case, for the reason that he was a work charged employee and you missed out on regularizing. You regularized about 8,000.
He is not the only person who was missed out, Lordship. There are more than.
But
around-
does it-
there
does
should
it-
be-
does
will
it-
be- It will be
does
more
it-
than 30,000.
Does it act as a sketch-on on your, as a,
What
does it not act as a
If
blot on
not-
your
if
sketch-on?
not- There's that entire scenario.
Second affidavit at page number?
Dr. Gitse, in fact, Lordship, entire affidavit I have to read. Lordship, last regularization was in the year 2005. At that time, Lordship, around 30,000 were regularized, master roll as well as workers. Even thereafter, Lordship, our policy for.
He died when?
In 2000.
Died when?
Expired in 2011.
In 2005, why did you not consider him?
Lordship, at that point of time, 30,000 names were received. Accordingly, authority cabinet considered, given approval, their services were regularized by creating professional posts against each person, Lordship. Now, Lordship, at that point of time also, thereafter also, Lordship, in 2006 also, we issued notification to all the departments calling for names, Lordship, whose names were left in the first term in 2005. In the meantime, Lordship, that Madhavi judgment came. Another judgment of full bench judgment of our High Court came, Lordship. Accordingly, we filed an application before this honorable court, paying for leave, allow us to regularize the service or continue with the policy of regularization. If Lordship looks at the judgment passed by this honorable court, Lordship, in this case, Lordship. This is page 164 of this affidavit, Lordship.
What is it?
Court said if it is not prohibited by law, Lordship, how
We
can this
cannot.
honorable court permit?
वही है, उसको मैं पूरा handle, आपको मैं दिखाऊं, इसलिए दोनों इसको क्या अगर hearing करते हैं तो आपको मैं दिखाऊंगा what is understanding.
My understanding also. My understanding also. Please come on.
According to the fully sustainable.
There we stand, Lordship.
Conclude कर रहे हैं.
तो पहले देखते हैं बोली जाने दीजिए. इसमें vast
Something has to be done for this, for these kinds of cases. This calls for some distinction. क्या नाम है उसका? राजकरण. What is that case? Rajkaran and
राजकरण सिंह.
Rajkaran और दूसरा कौन है?
दूसरा है विनोद कुमार.
नहीं, विनोद कुमार तो हम लोग देते हैं.
then इससे पहले है प्रेम सिंह.
You do some exercise, mister. You do some exercise. Please give us all such list of cases of Supreme Court where some concession has been made for a case like this. Of course, the Supreme Court in many of the cases has given that concession under Article 142, notwithstanding the law, which power we don't have. But then this calls for an interference. Because there was something lacking on the part of the state. Inadvertence, oversight. आपकी case है, you please work out. Give us the list of all such cases. Prem Singh, Rajkaran और वो नहीं वो जो अभी कवाला जो है.
Our High Court.
Jago.
High Court has decided.
Jago will not apply here. Jago will not apply. But Mr. Nayak, think about it.
I found only one judgment that has been passed by your lordship, sitting in the full bench of the High Court.
Which judgment is that?
Is Mubina after lordship.
Mubina was a different issue. We said that because what was happening in that state was that any person who came, any widow who came for post-retirement benefits, for pension, fixed pension, family pension, some were given by the court orders, some were not being given. So there were divergent opinion, and therefore in the meanwhile, the matter was referred to the full bench. It was under those circumstances that we held that work charge establishment cannot be a regular appointment. But over a period of time, Rajkar and others, they say that no, well, this is this work charge establishment because it has some continuity with it. Though it was only ad hoc for the purpose of a particular project, but it became, a perennial kind of an organization with perennial service. In that case, we invited the government to frame rules. But in the meantime, before the government could have framed rules in the interregnum in order to avoid such disparity in judgments, we legislated. We gave a interim measure how to deal with such women.
Yes.
And you would be surprised and you would be happy to know that after some time, the same legislation, the same thing what we had stated, the same framework was notified by the government as proper rules and gazetted. We had thought that this matter would be further challenged before the Superior Court. No, they did it because there was sense there. Correct. Mubina Khatun, you got what have we said there?
In therein also, Lordship, in paragraph 54, your Lordship has said that such benefits cannot be given through a process. I mean, it is not permissible through legally permissible laws. 54, Lordship.
There the distinction was sought to be made with work charge establishment. The entire context was different.
Yes, Lordship applied the equitable jurisdiction. That is the.
And holding that equity only begins where the law ends.
For that also, Lordship, Umadevi has addressed. On that point also.
We need to recalibrate our opinion. Let's see. We'll keep it for hearing. आप तैयार करिए कुछ.
We have to rely on this Jagu's case,
Jagu has no application. Don't take that shortcut for a lady whom you are representing. She's a widow, and her husband had worked for 30 years. All others have been regularized. She has been left out. I don't know for what reason. आप उस पर बहस करिए. Don't rely on Jago. Jago is contextually absolutely different.
Why should I suffer for the mistake of the
He
government?
doesn't want to. You want to conclude your arguments? You want to conclude your arguments today? Haven't you followed what the court is saying? बताइए आप बताइए tell him.
We'll follow the directions. Follow the direction.
Mr. Das, Jagu is in some different context. It was for regularization.
Yes.
Here the question is not regularization. Your argument should be something different.
No,
Raskaran, then Binod, everywhere they have made a distinction, and in fact Umadevi has been interpreted saying that Umadevi's intention was to stop irregular entry, backdoor entry, and stop regularization, not for the purpose or to allow that they will continue an exploitative engagement. This was the interpretation in subsequent.
Make some more preparations, come back to us. Arguments to continue. Let's this matter, you also do it. Arguments to continue. No, we are seriously contemplating, Mr. We understand your difficulty that there would be about 1,000 or 2,000 people.
30,000.
30,000 people like this.
30,000.
That's what is holding us back. That is what is holding us back, Mr. Nayak. Otherwise, we would have passed an order today. Once we pass an order, that would be a precedent. You can always have it. You can always have it annulled by the Superior Court, but then here we can't just sit back and see this happening.
Only point is, Lordship, whether without regularization a person is entitled to pension or not. That is the only issue, Lordship.
You think it's a minor issue in this case?
No, ultimately.
You went ahead with regularization process. You gave that benefit to 8,000 and thereafter 13,000. The husband of the appellant was eligible for all that. By mistake, you forgot. Oversight. And then Posthumous, your officer also wrote to the department that please do it. This lady would be the only exception. But still you sat tight because there is a huge number of such persons. But every case has to be decided. Now we understand the financial implication of it. We understand that. But then, but what to do with this kind of fact? What to do?
No, this is not the only fact. That is what I am trying to emphasize, Lordship. There are so many people like her, Lordship. This is not the only person. And in all the cases, Lordship, all are similarly placed, Lordship, all were appointed prior to 1993.
This big number, they should be allowed to remain, high and dry.
That has been held, Lordship.
Aren't you a welfare state? Cases like this where every entitlement was there, worked for 30 years with all payment and everything, like a permanent employee, transferred, given higher responsibilities, and then because of your oversight, if it goes, I mean, forget about law. If that's, we'll say that it will not cause any precedent, but we want to interfere in.
Lordship will hear you.
We'll hear you. Arguments to continue. What is your name? We have heard Mr. S. Das and Mr. Naik. Mr. S. Das for the appellant and Mr. Naik, learned additional advocate general Assam for the state. Arguments to continue further. Re-notify. Arguments to continue. So we have heard so and so. Let us also contemplate how to handle this situation. We'll give the introductory facts here so that the appellant, the wife of one late Sutku Burman, who had initially joined government service as a muster roll worker in the Public Works Department, Kokrajhar, Rural Division on 17/9/81. Later, he was upgraded to the position of work charge Chowkidar on 8/8/1996. Vacant sanctioned post. These are the
Lordship, that you have already explained in my affidavit. He was
Let
never
us-
working in a sanction post.
Okay, that will be your argument.
This case.
Sanctioned, vacant sanctioned post, and was paid regular salary according to the applicable ROP rules. He was also extended all benefits of grade 4 regular employees, including GPF. His service was duly recorded and a service roll was maintained throughout his tenure. The records further reveal that in the year 2005, the state government introduced a scheme via office memorandum dated 30/9/2005 to regularize the services of muster roll and work charged employees who had joined before 1/4/1993. More than 8,000 such employees were regularized under this policy. Later, approximately 13,000 more persons were regularized under the policy referred to above. Is that because of an administrative mistake or oversight perhaps, of the Executive Engineer Public Works Department, Kokrajhar, Rural Roads Division. The name of the husband of the appellant did not find mention in any one of the regularization list, despite his having met all eligibility criteria. This inadvertence / mistake was noticed by respondent number 4 / executive engineer, who communicated with the government for considering the case of the husband of the appellant for posthumous regularization so that the appellant / widow could be granted family pension. It has been argued by Mr. Das that the late husband of the appellant served for 30 years, but today she does not get any money from the government under the family pension scheme, for the reason that, for whatever reason, the service of her late husband could not be regularized, even though many others similarly situated were regularized. The facts of this case, very sad scenario. Mr. Naik, learned Additional Advocate General, however, vehemently argued that sympathy ought not to change the course of law. And there are more than 30,000 persons similarly situated who would also have to be given family pension. The present case is allowed. He has further submitted that he has further disputed certain factual assertions that the late employee worked against sanctioned vacant posts. Arguments to continue further.
Figure of 30,000 is 23.
Approximately 30,000. Approximately 30,000.
Can you have the figure?
Can you tell us the figure?
Yes, I can have it.
Approximately 30,000.
I have
Bracket
to
में
collect
लिखना,
the data from
figure
all
to
the
be,
victims.
this figure to be re-verified. Bracket.
Place the figure in the Supreme Court.
देखते हैं, let us see. We will make it without, but our sensibilities are hurt with this, if the fact is correctly asserted.
What to do? Or against our effect.
इसको डेट दो in May.
May 4/5. Sixteen.
Yes.
5-9 already.
Great, your lordships. My lord, by this petition, I have challenged the benefit.
1 second. We have heard this matter and अच्छा, the order ये लिखा है क्या लिखा? Just the order dated 5/9/2025 for us. तो disposal of the writ petition में कर दिया. Then in the meantime, till the disposal of this writ petition, the DRT shall not pass any order dismissing the appeal as infructuous for the petitioner not having an answer. So it's still pending at the admission stage. It has not yet been admitted.
Yes.
Have you brought that judgment where the Supreme Court says that this word, any other order, has to be interpreted differently? Where is that judgment? Sunshine,
Yeah, next is at page 94.
page 94.
Yes.
Sunshine Builders, yes.
Record भी किया होगा।
Yes, which paragraph?
My lord, yeah. Paragraphs,
Paragraph 16, Lordship. 15 and 16.
15 and 16.
The only difficulty, Mr. इनका नाम क्या है? ये तो he has argued. Huh? Mr. Bhatti,
Yes, ma'am.
the only difficulty here is this. Now, paragraph 15 is all right of this judgment. It should be given a meaningful interpretation. Agreed. Now here, you are claiming that there was no equitable mortgage on record.
Yeah.
The bank says that no, they had the original sale deeds. Now you are asking for the same to be sent for a forensic examination because the original lies with you.
Yes.
Right. So ultimately, it would, any action there would relate to, determination of the liability of the borrower. That is you. Ultimately, it will be the liability of the borrower.
Yes, my lord.
Lordship,
Definitely, I
yes.
agree, my lord.
Just a minute, let him complete.
I agree to that extent, my lord. But so far the action under SURFACE Act is concerned, that cannot be taken in that case.
That has been rejected. That
If it is not mortgage, my lord.
Why don't you do one thing? I mean, instead of getting into this controversy, we can say that for this purpose, no deposit is necessary. We can say that. But it's tinkering with law हो जाता है ना.
We'll have to go, suppose, the totally law cases is an decision application for sending it to forensic, not touching the.
That is all right. So, but it says any order. तो उसको बोलना पड़ेगा. It is not also. But ultimately, it'll determine the liability. So therefore, the prescription allows. Yes.
Lordship, he has filed a similar application in the original application, sir. And that was rejected and he has gone to DRAT. That was rejected, then he came before your Lordship. It was withdrawn. So for in original.
That's all right.
application,
His argument is very simple. It is based on sunshine.
Yes.
It is based on sunshine. Now, for all other matters, you allow him to pay that amount. But here, it's just a question of sending it to the forensic. Otherwise, you can say that we will not send it. You have the forensic examination done from recognized institute and we will accept that. You can say that. But you can't insist for payment of 35%, which will run in several lakhs.
No,
What is
Lordship,
the outstanding amount? Just a minute. What is the outstanding amount?
so for Lordship,
Just answer the question.
Total-
Arguments you can make.
Total
What is the outstanding
2
amount?
crore 20 lakhs something.
So 35% of this would be how much?
that can be reduced, Lordship. That is the power in the.
Just a minute. So it could have been reduced to 25%.
Yes.
Even 25% of 2 crores is what?
No, that is not, this one, Lordship, a deposit is held by the Honorable Apex Court. That is not a deposit to the bank. It lies with the DRAT. And if he wins in the appeal, it refunds that. That is a certain law.
Achha, it is returned.
That is
The
what
amount
the
is
bank is
returned.
going to pay back.
Why don't you take a call and be ready for 25% only, not 35? I
No,
think
that-
something he will get.
Yeah, that he can make in the prayer he has come into waiver, that your Lordship can make it.
No, the law, I mean, if we give a meaningful interpretation, this does not require a pre-deposit, the issue. It does not determine the liability now. Liability will be determined later.
No.
If the bank is in a position to say that, well, equitable mortgage, there is evidence.
Let them hear this.
So,
You are also delaying the entire decision making. And therefore the loan has gone bad. He is not paying. You have fallen in his trap, in Mr. Bhatti's trap.
What is that?
So far liability is concerned, Lordship.
Is not proceeding.
That has been decided in the.
It's not कोई जरूरत नहीं only, but that will be decided.
This is in your interest.
Yes.
showing that this is pending, this matter is pending, DRT proceeding is now stalled, isn't it?
No, DRT, DRAT, in DRAT.
ठीक है.
It is now in DRAT, Your Lordship.
So the,
No,
original is before the DRAT. Original is before the DRT.
DRAT.
Take down.
And again,
Now we are saying that this appeal does not require, let the DRAT, we have said DRT. Why did we say DRT? No, why did we say DRT?
Yes, the order of the DRAT, it's not DRAT.
We have corrected it.
That's recovery appellate tribunal.
Disposal of the writ petition.
Appellate tribunal, just clarify, in the appellate tribunal, what is pending is rejection of his application for
Sending it for forensic examination.
That is pending.
So there is a,
Original is pending.
so
still,
there is
so
a,
that is getting delayed.
there is a mistake here, we will say.
So that is
Like,
incorrected. We have corrected by in an IA.
Have we corrected it?
Yes,
No,
yes. Instead of DRT, we have written it there is.
Isn't it? There is a mistake and we have corrected that typographical error. DRT and DRT.
Have we corrected?
Yes,
that?
it was corrected.
Where is that order?
The subsequent order, my lord.
Okay. No, look here. We have heard, I mean, let the appellate tribunal decide without charging anything from.
No, that will be a wrong precedent, Lordship, in my humble opinion. Because
No,
the
no.
Honorable Apex
No,
Court,
no.
in very many decisions, I will place before Lordship, that even in interlocutory application, the free deposit is required.
Sunshine doesn't say that.
Sunshine Lordship, so far Sunshine decision is concerned.
And look at Mardi Chemicals also.
That.
Mardi Chemicals says that any amount is bad. But what is
Basically.
happening? Just a minute. We would like to know, Mardi Chemicals, the Constitution Bench judgment says that this pre-deposit scheme only is bad. What happened to
That is
that?
so far, Lordship, if after Mardi Chemicals, that is so far in original application is concerned, that is after section 17(2) has been amended. That is so far section 17(2) is concerned. Here lies Lordship, section 18.
So
That was section 18. Now, so for section 18 is concerned, I am placing your Lordship will pass the judgment.
No. We will take into account. It is not our sweet will. We will go by law.
Yes,
He's a defaulter. He's trying to hoodwink the bank
yes.
only for this.
My lord will just go through the judgment of the Honorable First Narayan Ghosh case in the our Apex Court.
It is after Sunshine.
No, before Sunshine. That has been, yes, for, and after
It shall be
Sunshine,
refined.
this is the decision of this Honorable Court. After Sunshine,
Okay. Just
by the division bench of
Just
this Honorable.
catalog all judgments together and we are coming back after 5 minutes. Catalog all judgments in. Yes.
I've given. The first decision my lord will find, decision of this Honorable Court on 3/11/2025. I'll take your lordship to.
We'll keep it for tomorrow. Let us go through it. Because up till now, we are of the view that Sunshine is the last word there. Correct?
Yes, lordship.
So let's see. Because
From
we'll have to see whether an order which does not determine the liability, whether there should be a pre-deposit, insistence on pre-deposit. That's all we will see. We'll see all
For
these. charges.
determination of liability is concerned, that is also been held by the Honorable Apex Court.
That we don't question at all. That is
In the
the
service
statutory
possibility.
prescription. That we don't question at all. But look at the reasoning in Mardi Chemicals. Anyway, we'll see it tomorrow. Arguments to continue. Let this matter come up for
But
consideration.
let
On?
it come on Monday.
On?
Monday.
Monday, 2. Second,
So Monday is a special bench. We will not give. Then it comes on 9th.
9th.
Right.
As Alico. Arguments to continue. Let this matter come up for consideration on 9th of.
9th of March.
Matthew.
Supplementary list, item 29 for admission.
One matter, your lordship.
May it
Well,
please,
then,
your lordship.
I beg to appear, Manas.
No, I'm appearing like, sorry.
Yes, I'll just take 5 minutes, Manas. I'm seeking Manas notice from your lordships and appropriate interim protection, may I just point out, Manas, it's sad to say, but Manas, a constitutional authority in this state has, Manas, acted repetitively, habitually, consistently, and continuously by using Manas words of a vituperative campaign of hate. We have, Manas, got liberty from the Supreme Court to go first in 226 and not in 32. Just see, Manas, the consistency, continuity, and habitual nature of this person's actions, and more so for sure when you are violating your oath of office. Every known canon of Article 14, 15, the words of the preamble, Malas, secularism and fraternity, and specific 5 provisions of the statute. So let me place that very quickly, Malas, about the consistency of pattern.
Just a minute, just a minute, Mr.
Yes.
Singhvi, just a minute. Let
Yes,
us come,
certainly.
let us come to the page 87.
No, I think your lordships are on my petition. I'm in item 29. I'm Chandra Uday Singh.
Pages, Malas, pages may
I'm in
match.
item 29, but Dr. Singhvi, I think, is in another companion matter.
Dr. Singhvi, your matter has not been listed because it was not defect free. But nonetheless, we have called for the records of that case. Have you brought it?
16, it's writ petition number 16. It is, I'm told, it is before your lordships now, Manas.
No, this is, Dr. Singhvi, you will have to wait. We are summoning that file, even though you have not removed the defects, but then we'll have it within some time.
Very,
So
very
can-
grateful, very grateful, very
Can
grateful.
we hear it at 2?
2 o'clock. Very grateful.
Or we ask,
Towards the
or
end of
we
the day, towards the end of the day, 3 o'clock or whatever lordships.
no, 2 o'clock would be good.
Yes.
In the meantime, we finish all other matters.
Yes, Manas, yes, yes.
Your lordship will take all 3 matters at 2 o'clock.
Yes, yes, everything together.
Only 2 matters are there.
No, my lords, there is another matter.
I'm in item
that's,
29, Millards.
29 also is here.
That is
Just
Dr.
a minute, your
Hirendranath
counsel is
Gohen.
here. Yes?
There are 3 PILs, Your Lordship. Item number 29 is Hirendranath Gohen, Lordship. 2 other PIL, Lordship, is being numbered. It has been numbered, Lordship. This one is going for the bench.
Get all these 3 files.
Lordship.
So,
my lords,
yes.
I
Yes,
hope
yes.
that there is, amongst them is one of the matters where I appear, which is Communist Party of India versus Union.
Communist
India.
Party's case,
I
that's-
don't have a number right now. That I think should be, that was also not numbered, not listed.
My
Yes,
writ
this
is,
is-
So my lords, that can also be called for.
Yes, Ms. Arora, yes.
and my writ is 16 of 26.
Thank you. I'm grateful, my lords.
16
We assemble at 2.
Very well, very well.
In the meantime, let us finish all other matters.
Very well, my lords. Grateful.
Obliged, Millards. Obliged.
Obliged. Grateful, my lords. Grateful.
What's up, Mangwalo file?
Yes, sir. Otherwise.
Item 19 to 21.
Item number?
In this case, my lord, on 14/10/2025, my lords have passed an order asking me to take instruction from the government regarding the stand of my lord, whether government will revisit the rules, rule 11(5). But now-
Just a minute. Let us apprise ourselves of what happened. 14/10/2025.
Yes.
Now, please read that order, Mr. Goswami.
Yes.
You are younger than Mr. Chaudhary, therefore we are asking you to read.
I'll read my lord. We have heard Mr. K. Chaudhary and Mr. D.P. Chaudhary, learned senior advocates for the petitioner, and Mr. So-and-so, learned edition is the Assam for the respondents. The petitioners are junior engineers, civil in public health engineering department and irrigation department, government of Assam, appointed pursuant to a selection process conducted by the Assam Public Service Commission. All the petitioners have the basic qualification of diploma in civil engineering, enabling them to have participated in the selection process for appointment on the post of junior engineer. Some of the petitioners possess higher degree, that is bachelor degree in civil engineering, but they opted to go for appointment as junior engineer civil, for which the threshold minimum qualification is diploma in engineering. Some of the petitioners acquire higher degree, that is bachelor in civil engineering, and during their service tenure as junior engineer. They protested against the state government having advertised the post of assistant engineer, a higher post which is to be filled by direct recruitment as also by promotion, and claimed that by virtue of their being in position of bachelor degree in engineering or
acquiring such higher degree during service tenure, they are eligible to be promoted to the post of assistant engineer, which promotion according to the rules has to be treated as direct recruitment. It would be necessary to mention here that the service rules governing the service of petitioners, namely Assam Public Service Engineering Rules 1996, thereafter referred to as Rule of 1996, provides that the recruitment to the cadre of assistant engineer shall be made by direct recruitment and by promotion with a quota of 70% and 30% respectively. For the 30% quota of recruitment by promotion, a junior engineer would be eligible who has a minimum qualification of diploma in civil engineering or has an equivalent degree recognized by the Government of India and would have rendered 8 years of service as junior engineer as on first day of January of the year of promotion. Specific provision has been made in Rule 11.5 of the Rules of 1996, providing that notwithstanding anything contained in rules of the suitability, junior engineer of the Assam Subordinate Engineering Service PHC on his acquiring the academic qualification as prescribed for a direct recruit assistant engineer shall be promoted as assistant engineer in consultation with the commission as provided in Rule 14 against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of assistant engineer for the purpose of the rules. Armed and strengthened by the provisions of Rule 11.5 of the Rules of 1996 referred to above, the petitioners had approached the court against the direct recruitment of assistant engineers without first promoting the petitioners to the post of assistant engineer. A distinction was attempted to be made that Rule 11.5 would apply only to such engineers who have acquired the higher degree, that is bachelor degree in engineering, only during their service tenure as junior engineer, and not to such junior engineers who already had higher degree in engineering but choose to enter service as junior engineer. That there being divergent opinion of two learned single judges over the issue, the matter was referred to the revision bench. It would equally be profitable to extract the relevant portion of the referral order, which is as under para 22. The point of determination referred to for consideration of the larger bench is as follows: whether the use of the word acquiring as provided in Rule 11.5 of the Assam Public Service Engineering Service Rules 1996 would exclude those junior engineers who had already acquired the graduate degree in engineering prior to joining service as junior engineer in Public Health Engineering Department. Para 23, it is needless to mention that the division bench would have inherent and unfettered discretion to reframe the point of determination and or to decide any other point that may arise in course of hearing.
Now we have followed. So we could have returned the reference as not actually a debatable issue.
Yes.
Here the issue is that Mr. Chaudhary is a junior engineer who says that please don't appoint assistant engineers directly. First consider us, because we have put in 7 years, 8 years as junior engineer and we have the requisite qualification immediately on the vacancy in the cadre. Now this cadre would be the general cadre of assistant engineers. That is his argument. Whether it was acquired was immediate. Suppose somebody, see, this distinction is very illusory, Mr. Goswami.
Yes.
For the reason that suppose a person chooses to become a junior engineer, notwithstanding his qualification of engineering. Right. So right from the day when he joins junior engineer, he would be entitled, but no, there is a check because 11.5 can't be read in isolation. It has to be 8 years of service. Right. So on that strength, he says that now you're inviting application for direct recruits. We also would be on promotion, become direct recruits. So the cadre would be same. So we would be rendered junior, they would be rendered senior, because these are no subdivision in the cadre. Correct. So can they do that? I mean, question is this. Therefore, Mr. Goswami, you were supposed to answer. Can they raise this plea now? 30% of the judges from service are nominated, recommended for High Court. 70% from the bar. Can service people say that no, don't recommend the bar first? Juniors.
Factually, they have challenged the direct recruitment.
You have followed. I have given you an example.
Yes.
Please argue on that. Develop that argument on that.
Yes, madam. What has happened after this order, madam, I also tried to impress upon.
Don't fall in the trap of Mr. Chaudhary. He has formulated his argument in a very intelligent way.
Madam, what my submission would be, my lord, that Rule 11.5, as my lord has already said, has to be read with the other rules. That means even
What do you have to say about this? That we have understood. What do you forget about this qualification? What would it reply? We would have returned the reference. To tell you a fact, this reference is not to be answered because this was not germane to the issue which was being decided by a learned single judge. We could have said that this reference is not fit to be entertained by us. and we would have sent it back to him to decide. In that case, two things you have to argue. If we are not accepting this reference point as a topic of discussion today, which is relevant, then whether we can decide this without the single judge having decided the matter. These things you have to argue, no. We are not supposed to suggest
if
you.
my lords are not entertaining the reference, that not being a.
Yeah, this argument should have come in the first instance.
Then let the honorable single judge decide. But what actually has happened, well, in the meantime, since my lord passed this order, I also tried to impress upon the government department. My lord, they have come up with an instruction that they are amending the rule. But again, my lord, they are making the same, taking the same stand.
Rules have been amended.
Not amended, my lord.
They intend to.
They intend to, and their intention is.
In the meantime, what has happened to the direct recruits? Have you carried on the process?
But for these posts, my lord, all are appointed, my lord. Some posts were kept vacant for petitioners.
What is the clear stand of the government? Tell us today.
Clear stand of the government that they are amending the rule and the rule.
ये बहस करिए ना कि what is his right? The vacancy. The argument on merit is whether availability of. We will ask Mr. Chaudhary to expand on his argument, but I'm telling you, you are not prepared on this. Now, whether, notwithstanding the rules in place, unamended, what we have seen, whether it gives the junior engineers a right to claim appointment against vacant seats before the direct recruits.
No.
Can it
They
happen?
also have to put
So
in 8 years
therefore,
of
what
service.
logic do you say? What is the principle of
They
law that
also
you
have
say?
to put in 8 years of service.
Oof. That 8 years is given. Suppose after 8 years, and Mr. Chaudhary has put in 8 years. He has also the engineering qualification. And there is a vacancy also in the cadre. Because without vacancy, you would not have asked for appointments. So asked for direct recruitment because the cadre is same.
Yes.
Because promotees also become direct recruits. Correct. So the cadre would be same, seniority list would be the same. Can they say that when you do this, you first give us promotion? By which logic? Which law? Which law operates? They have a right to be considered. They don't have a right to be considered on time. Many posts remain. You have to provide some legal framework for
once they are
meeting his argument.
Once they are promoted, they will be treated as direct recruit. But before that, they are normal promoting. So they have to claim.
He disputes that. Is he disputing that?
So they have to claim against those 30% vacancy.
No. Claim against 30%, but before, later, simultaneous. These are his questions.
But in this case, they have claimed against the
Suppose
right
30%. Suppose 30% quota. No. 30% quota. Or have we just created a ghost? You didn't ask for it. We have created a ghost for us to answer.
Yes.
You asked for it.
No, my lord, our purpose would be served as long as our case is considered.
Suppose they will be appointed against the quota of 30%.
Yes, ma'am.
Whether if they are promoted simultaneously with the direct recruits, then perhaps seniority would be determined in a different way.
Different.
In that case, promotee would get the seniority same year.
Same year.
That is
That is not the issue here.
My lord, the problem is created because a distinction is sought to be made between acquired and acquiring.
No, that is
That
we have.
clarifies, then let single judge decide it.
So only thing that अगर ये लोग ऐसे interpret
Take down.
कर रहा है कि ये
It doesn't matter.
next day he's entitled to the
Just 1 minute. See, government has come up with these instructions, which will again complicate the issue because they are not changing anything. They are basically rewriting the same thing.
Why do you keep this? That is for the single judge to decide.
Because they have challenged direct recruitment. They have
No, my lord,
challenged the
whatever
APSC
may be the
notification.
challenge, that will take care. Only thing is, my lord, now a distinction is sought to be made between a person who has acquired and acquired during the course of service.
Well, that I have also given up my lord. That argument.
My lord, actually, my lord,
The rules like
going by the all India service rules, my lord, normally what
But
happens.
your claim against this direct recruiting on the ground that because moment we acquire, we should be first given. That is your case. That's why police say.
Let us be very clear about one thing. Notwithstanding the fact that we would be treated as a direct recruit, but we will be promotees. That reconciliation has to be done.
No,
So
you
we
keep
clarify that
promotees.
position.
For what purpose? Promotees or direct recruits? How does it make a difference if in the civil list you are in the same cadre?
The rules
समझ गए, they immediately.
वो बोलते हैं कि हम direct होने से भी we are promoted, so we'll have a advantage.
They merge in the same cadre.
Direct repeats के अंदर में चले जाएंगे.
देखें वो rules दो तो.
No, Millard, there is some
Give us
confusion
the rules.
regarding one aspect. Let me clarify that.
When are you coming up with the notification?
Well,
Amendment?
It will take some time.
How long a time?
They say it is under process. After obtaining finance concurrence, it will be for the cabinet.
So therefore it is almost at the stage of.
No, Millard, the stand which they take, nevertheless, the same position will continue, the reference will still survive. Irrespective of what they do, Lordship will only answer the reference or in whatever manner Lordship would like to. Let single judge decide the case.
Rules though, no, bhai? Rules of 1996.
Yes, ma'am. They are separate pilot.
Public Health Engineering Service Rules of 1996.
Yes.
Yes.
Well, they joined the year 2019 and immediately within 1 year, they say we should be wrong.
समझ गए. That they can't. Unless they complete their 8 years.
Yes, ma'am. That is precisely one of my argument, my lord.
Don't question it.
So that's why I'm saying, my lord, my argument of acquired or acquiring, I'm giving it up, my lord.
Okay. Now, which provision direct recruit?
Rule 11, my lord.
11.5.
We'll read 11 in entirety, my lord. Promotion as assistant engineer.
Yeah, we are on a different, this is a SAM Engineering PWD service.
PHC, Public Health Engineering.
Irrigation or
Can you have a copy of those rules? उधर है दीजिए, Mr. Goswami.
Rule 11, ma'am.
Mr. Goswami, you have only one copy. Then I give it to my brother. I will not see.
I have given already copies, ma'am, to the court.
I think in the referral order it is quoted, Millard.
No, we'll see it from what we have quoted. We don't know. We'll read it afresh.
Rule 11, ma'am.
Just a minute. इसको पहले हमको देखने में क्या है. This is called Assam Public Health Engineering Service Rules. Method of recruitment. 70%, 30%. Value to 3 of 11. Annually, the number of respective theaters have occurred or likely to occur, subject to the suitability.
Vacancy ne kehta. Ito to kona agency quota promotion. Okay. Vacancy indicator. And such promotion will be treated. No kotha to all baby it up puts. But again, Kedra question has 30% promotion, 30%, 70% direct recruitment. It will clear it like it.
দিয়া এটাও লৈ ললে যে
এইটা সেন্ট্রাল রুলসৰ লগত মিলাই দিব লাগে যাৰ ডিগ্ৰী আছে তাক 5 বছৰ কোৱালিফাইড চাৰ্ভিস যাৰ ডিপ্লোমা আছে 8 বছৰ কোৱালিফাইড
এটা কৰিব লাগে
কিন্তু অলৰেডি তাত সেইটো আছে এইটা অদৰকাৰী কিয় লাগে
Yes.
Milord, I have one question, Milord. If your lordship would kindly read the last 3 sentences. Shall be promoted as an assistant engineer in consultation with the commission as provided in Rule 14 against the next available vacancy in the cadre. That is one aspect. And other aspect is, and such promotion shall be treated as a direct recruitment to the cadre of assistant engineer for the purpose of these schools. I understand, Milord, the purpose of reference was use of the 2 expression in the rule, cadre and will be treated as a direct recruitment to the cadre.
No, the reference is only one.
No, Milord. The purpose of reference was perhaps
Purpose was this, but
Ah.
reference has been made only with
Yes.
limited mandate,
Yes,
limited remit,
acquired and acquired.
not remit, limited, limited, what do I say? It's not remit from a single just to, limited aspect is whether acquired certificate also will have the same value, whether acquisition or acquired during the period. But then the word is, has minimum qualification of diploma in engineering as the government has rendered 8 years. So the requirement is that he should have a degree on the date when the vacancy is announced,
Arises.
when he applies, when his name is considered by the commission, and he should have passed all departmental examinations and should have rendered 8 years of service. So this distinction is illusory whether he had from before or he obtained.
I'm not on that, Milord. I'm
Yes.
on the further thing, Milord. Absolutely, Lordship is correct. Because a person with a degree, he becomes junior engineer. His cause of action will arrive the day he completes 8 years. The other requirement is there must be a vacancy in the cadre. To that extent, I understand, Milord. But the last part of this sub rule
Shall be
five,
appointed.
and will be treated as a direct recruitment to the cadre. That means he will eat up which quota, 30% or 70%?
30%.
Very
The
well,
reason
Milord.
is, I'll tell you what.
No, it's okay, Milord.
No, I'll tell you the reason.
That
It
is my
not
understanding also.
It is
but
not my choice.
Giving a literal meaning of this last sentence as if he'll eat up the direct recruit. My understanding is also he'll eat up promoting quota.
Promoting quota. The
Yes.
vacancies, now read 11.3. The vacancies to be filled up by
Promotion of service
shall be so fixed as the promoter shall not exceed 30% of the total corresponding quota. So this
So harmoniously reading 3 and 5, it will
Makes
be
it very
one
clear.
promotional quota.
But then the third ghost which I created of my own unnecessarily, if they delay in your promotion, you in this general civil list, you become junior, but nothing can be done about it. And that is not the reference before us, so we don't do anything. In fact, if I were there for formulating the issue or for arguing the case, I would have said that this. Now, the moment vacancy arises, it has to be notified by the end of the year. And that is for the expected vacancies also. You promote me. If I have done 8 years and if I have passed departmental examinations and I have the degree. So in that case, the time that you take in notifying for direct recruitment afresh, we get in. And therefore, in the entire civil list, we become senior. You argued this before the single judge. Now we are answering the reference. Correct? There's no difficulty.
Last one submission, madam. Why I was always harping on that acquiring during service because they wanted to give an interpretation that 8 years is not required for him.
No.
They say since we have already acquired,
We
it is
will,
not.
while answering the reference,
Yes,
we clarify.
because they joined in 2020, within a year they wanted the promotion.
Their whole case was that only.
Exactly, madam. That is why I was harping on the point of query.
It's a fact, right to be considered for
Chalo.
promotion is a right, right
is
to
the
promotion is not a right. That I appreciate, Milord. Only thing
They
is,
wanted to
Milord,
get rid of this 8 years of
unnecessary, no. Milord, best thing for the state would be like All India services, Milord. When it comes to diploma holder, qualifying service is 8 years. When it comes to degree, qualifying service is 5 years.
Yes.
That distinction should have been maintained in the rules, as is in other service rules of the central government and other states.
We have heard Mr. Ken Chaudhary, and senior advocate for the petitioner, and Mr. P.N. Goswami, senior advocate, additional advocate general state of Assam for the state. The Assam Public Health Engineering Service Rules
Sir,
19.
kind permission, can I take?
Please. The Assam Public Health Engineering Service Rules of 1996 that recruitment to assistant engineers shall be made by direct recruitment on the basis of selection made in accordance with Rule 6 of the body of rules, 6 of the rules, and by promotion in accordance with Rule 11, 13, and 14 of the rules. And the percentage of filling up the vacancies in the cadre of assistant engineer through direct recruitment and on promotion shall be 70% and 30% respectively for direct recruitment and junior and on promotion from junior engineer to assistant engineers. For promotion as assistant engineer, the rule requires that the appointing authority, Rule 11 requires that the appointing authority shall publish in the official gazette annually the number of vacancies in the respective cadres of assistant engineer which would occur or likely to occur in the year. Thereafter, subject to the suitability as may be decided by the selection board and by the appointing authority in consultation with the commission, an officer belonging to the corresponding cadre of junior engineer in Assam Subordinate Engineering Service shall be promoted to the cadre of assistant engineer, provided that such promotion would not be in excess of the 30% of the total corresponding cadre strength of permanent and temporary assistant engineers, that the junior engineer for promotion must have minimum qualification of diploma in engineering or equivalent as recognized by the Government of India. He would have rendered minimum of 8 years of service as junior engineer on the 1st January of the year of promotion. There is a further requirement of such promotion being effective only if the candidate has successfully undergone the training and has passed the departmental examination, if any, as prescribed by the employer/government from time to time. 11(5), however, indicates that notwithstanding anything contained herein, notwithstanding anything contained in the rules on suitability, a junior engineer of the Assam Subordinate Engineering Service, (PHE), on his acquiring the academic qualification, as prescribed for a direct recruit assistant engineer, shall be promoted as assistant engineer in consultation with the commission as provided in Rule 14, against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of assistant engineer for the purposes of the rules. Rule 14 Rule 12 further provides the special procedure for promotion to assistant engineers. Assistant engineers. The petitioners before the learned single judge were the junior engineers civil in Public Health Engineering Department and Irrigation Department, Government of Assam, appointed pursuant to a selection process conducted by Assam Public Service Commission. So all the writ petitioners had the basic qualification of diploma in civil engineering, have undergone 8 years and have rendered 8 years of service as junior engineer, making them eligible to be promoted to the post of assistant engineer, which promotion would be akin to direct appointment. The petitioners were aggrieved by the Verification, advertising, filling up of posts under the direct quota before the promotees who had acquired the who had acquired or had the qualification of diploma in engineering or equivalent and had already rendered 8 years of service as junior engineer. क्या लिखा है? पढ़ो, बढ़िया. If there is any mistake, we'll correct it later. Don't worry. Engineer, apprehending that with the direct recruits in the cadre, which is a common cadre, even if they are promoted, subsequently, they would be placed below the direct recruits. Appointment would be made earlier in point of time. It was with this contention that the writ petition was argued. However, the referral judge was under a doubt whether a junior engineer be eligible after 8 years of rendering service as such, when at the time of his entry in the service, he already had the academic qualification, making him eligible for applying for the post of assistant engineer. Or should it be limited to acquisition of such degree during the tenure of junior engineer, Full stop. On such issue, the matter was referred to a division bench. Full stop. On 14/10/2025, while dealing with the issue, we tentatively were of the view that such distinction would be flawed for the reason that it does not serve any purpose, nor is it logical. Mere acquisition of degree at any point of time would not render a person eligible for being appointed as assistant engineer promotion unless such junior engineer has served for 8 years. Full stop. In such a situation, whether the academic qualification was acquired during the tenure of the junior engineer, or he already had that qualification from before but chose to serve as junior engineer for the avenue of employment, not to make any difference. No, what did I say? I forgot. Sentence was big enough.
In such a situation, whether the academic qualification was required during the tenure of the junior engineer or he had already had that qualification. He already had that qualification before.
Before joining the service. The employment would not make any distinction. Stop. The eligibility requirement gets completed only when, with such academic qualification, a junior engineer has rendered 8 years of service in that position. Stop. That apart, a composite reading of section 11 would make it very clear with rule 11, ye tha na? With rule 11, we'll make it very clear that the respective quota of direct recruits and recruitment by promotion has been fixed, which is 70% for direct recruitment and 30% for promotion. 30% for promotion, full stop. A junior engineer would be eligible for being promoted on the notification of the vacancy position and also the process undertaken by the government for filling up the aforenoted quota of promotion, recruitment by promotion. In any view of the matter, such distinction between the threshold/eligibility degree either having been acquired during the service tenure or even before would not make any difference in the recruitment process. Full stop. Any dispute with respect to any delayed appointment by promotion, क्या लिखा है? What any promotion is an issue which would require consideration by the learned single judge. Full stop. We have been called upon only to answer the reference, which has we have been छोड़ दो, वो लिखा है. The reference is answered accordingly. The matter is remitted to the learned single judge for disposing of the case. The interim stay, no, that we will not.
We're keeping those posts.
The learned single judge would consider lifting the interim stay on the recruitment process in whichever quota.
Their contention that my lord has recorded, it was never their contention that they have put in 8 years of.
Sir, we have counted the issue and.
They have never put in 8 years of service. Within a year they came.
Okay.
Okay.
No.
Where my lord,
8 years wala contention में छोड़ देना वो 8 years. You do it, we'll correct it. All right.
They wanted because of graduation that.
No.
That is why, my lord, I was saying they are bypassing others.
Chalo, yes. Yes.
Deeply applied.
Preferably on, give a date in April, May, whatever. April.
27 April.
Deeply.
Oh, the parties are here. Yes, we will hear.
Item 22. Mr. Sailu.
Yes, Mr. Silo, today we are here with your case. You were apprehensive that every time.
I apologize for the previous court date, my lord. I overstepped my boundaries and I apologize for that, my lord.
No. Solid. Yes.
Yes, my lord. This writ appeal has been preferred against the judgment and order dated 29/11/2019, passed in WPC 121 of 2017, my lord, where my writ petition as the petitioner was dismissed. My lords, this matter in a nutshell is confined to the arbitrary and illegal alteration of my date of birth and date of retirement by the state respondents as against what is recorded in my service book and service card, my lord. And this at the fact end of my career, my lord.
Hearing you. Continue.
My lords are not visible. Is that okay?
Why are we not visible?
I do not understand
The problem is from your side. I am seeing, and our faces are very, very visible on the screen.
I have turned on everything, but my lords are not visible. I can continue with it. It doesn't matter. It doesn't matter to me, my lord.
Please continue. We can
Yes.
see you. We can see you. We can hear you.
Yes, my lords are audible from my side as well. So that is fine with me. May I take your lordships through the brief facts of the case, my lord?
Yes.
My lords, I'll state the brief facts in sequential order. My lords, after graduating from IIT Delhi in the year 1980, I have entered service by joining the PWD Public Works Department, Mizoram, on dated 10/03/1981 as junior engineer on officiating basis. After this, I was appointed to the post of assistant engineer on temporary basis on dated 31/8/1981, my lords. My lords, thereafter,
Mr. Silo referred to facts which are necessary or germane to deciding this issue of change in the date of birth. Now, whenever you are promoted, that's not in question. When was this objection raised? When was the service book prepared?
Yes,
What was
my
your
lords.
matriculation and certificate? Say, give
I'll
those dates.
come to that, my lord.
Dates are irrelevant for us.
I'll come to that, my lord.
Yes.
My lords, with regards to the date of birth, which is recorded in my service book and my service card, my date of birth has been recorded in both those records as dated 18/10/1960 upon joining service, my lords. 18/10/1960.
60.
Yes, my lords.
1960.
Yes, my lords. And I have placed on record before this honorable court all the confirmatory, requisite confirmatory documents as required by the fundamental rules, such as higher secondary certificate, my birth certificate, along with other government issued documents such as voters ID, Aadhaar card, and so on, my lords. Now, my lords, what has happened is, and along with this, my lords, a final interstate seniority list was issued on dated 04/03/2010, my lords, wherein my date of birth has been clearly recorded as 18/10/1960 and my date of retirement as 30/10/2020, my lords. My lords, now what has happened is that I have been in service for more than 35 years. I have rendered service for more than 35 plus years. And somewhere in the year 2000, towards the end of 2016, the state respondents have made an allegation that I have taken out my service book in the year 2008, specifically dated 31/7/2008, my lords. And that I have returned the same on dated 22/01/2015, my lords. Now, my lords, thereafter, the state respondents have made a claim that I have that while the service book was in my possession, in my custody, I have tampered with my service book and made alteration to my date of birth from 10/10/1957 to 18/10/1960, my lords.
Yes.
Now, my lords, after this, the state respondents have sent my service book along with my service card for examination to the FSL, my lords. And the examination of the FSL report of the FSL came back on dated 20/03/2017 and dated 16/5/2017, my lords. Now, my lords, thereafter, the state respondents initiated a departmental proceeding on the basis of this regarding the allegation that I have changed my date of birth in my service book. I have made alteration and tampered with my service book. And they have initiated a departmental proceeding somewhere towards the end of 2016, my lords. And thereafter, my lords, as such, a memorandum of charge was served to me on dated 17/2/2017, my lords. My lords, should I continue?
Just a minute, just a minute.
My lords.
Younger brother का age जो है so 59 में retire कर जाता है. Younger brother was not younger brother was born in 1959. He was in civil offense. उसके basis पे क्या है? ये tempering वाला तो गलत हो गया क्योंकि इंक्वायरी में कुछ नहीं पाएगा.
हाँ, तो forensic में भेज दिया.
Forensic क्या है?
ऑर्डर कोड किया.
क्या है?
57 में क्या ब्यूटीफुल हिस्ट्री है.
पेज
Page 251.
नहीं, इसमें क्या है पैराग्राफ? विच पैराग्राफ से शुरू करता है?
इसके पैराग्राफ देखो 11.
एक मिनट. कहाँ पर क्या लिखा है?
पैराग्राफ 3 में है उसका सब पैराग्राफ.
Is not the original word entered. क्यों रखा हुआ था सर्विस बुक from 2008 से 15? But Mr. Silo, why were you keeping the service book with you from 2008 to 2015?
My lords, I would like to come to that, my lords. Although we have not placed it on record before this honorable court, my lord, but I have furnished a copy of an RTI reply which we have received from the department from the DP and AR Civil Service Wing, my lords, wherein we have raised questions regarding the departmental proceeding which was initiated against me, my lords. And in this, my lords, in the RTI reply, they have furnished a copy of the written statement which I have submitted against the departmental proceeding which was initiated against me, my lords. And in this written statement, I have clearly stated that I have not.
All right, Mr. Silo, this is time for us to rise.
My
So
lords.
we will hear you by around 3
My
because we have
lords.
fixed a matter where lawyers from outside are here since
My
at
lords.
2 o'clock. So
My lord.
after that we will hear you.
166, 167. Then, Malus, 166 and 67 is the gun pointing. 169 is the visibly religious emblematic image. Again, 171 is the religiously emblematic image. And Malus, your lordship comes to 177, another graphic image. Then Malus, 178 is a, if I may say so with respect, Malus, a constitutional cowboy image. I do not know, Malus, but there is apparently a constitutional cowboy also, which Dr. Ambedkar forgot to mention in his articles. And Malus, so on. Now, Malus, kindly come to page 162. And remember, Malus, this is reprehensible and inexcusable by anyone. But if there can be degrees, Malus, when your lordship takes an oath, when I take a public office, when he is the chief executive of a state, this is, Malus, beyond a fortiori. Now, 162 is a second example. A day earlier, just turn to the first para, last 2 lines. And I'm sorry, on the previous one, 4 days later it is taken down on the previous one. After over 1 million views, I've averred all that. And well, some lowly functionary is blamed, though your lordship will see on those photographs, the BJP official handle is there. Official handle is there in all those images. Show the actual official handle. Which page?
Yes, we have it.
Yeah. Now, let's come to the previous day, 162. That's why it's now a habitual, consistent, repetitive pattern. It's not a straw in the wind, a swallow in the summer. 162.
Yes.
Cited Mahatma Gandhi. This is the greatest irony. Mahatma Gandhi is cited. There cannot be something more ironical. Saying that non-cooperation and civil disobedience were ways to create an environment in which they cannot stay in Assam. Whereas I can only say with respect that Mahatma Gandhi would turn over in his grave on this interpretation of civil disobedience. That's my understanding. I may be wrong. Then let's come to page 163 in the middle.
Yes.
A distinction between Miyas who he said were illegal immigrants. My system is civil disobedience and non-cooperation. Do not give shelter to Miyas if they are Bangladeshi. Learn the distinction between the Miya and the Muslim. In the name of Miya, don't harass Muslim. In the name of Muslim, don't give protection to Miya, etc. And let's now turn to 156. 4 days again previous to this. 156. Oh, no, sorry, not 156. Sorry, it's 156. Yeah, 156. That's correct. Yeah. Well, as a rickshaw puller on video, if your lordship will play the video, it's been supplied, I believe, with the petition, is harassed purely because of the minority group to which he belongs. This is how Assamese youth in search illegal Bangladesh Miya Muslim now in every lanes. And then, well, this goes on till 161. We have provided a pen drive apparently. I don't need to repeat it. It's obvious what they are saying and what they are doing. Basically, also all of them is accompanied by make them leave, exit them, report them, throw them out. The habitual nature of this goes back to one of those rare instances of 23 when another constitutional authority, which should be acting much more often, did act for once, but then apparently forgot about it. 112. This is 19-10-23. This is an EC. Format 2 is correct. Is it an EC?
Which page?
112. Now this person, not only is the #1 constitutional authority as far as executive function is concerned in this state of your lordships, but also makes these comments pan-India. This comment is made in Chhattisgarh. So the whole of India is, as far as his verbal attempts are concerned, is his playground. Middle of page 112. To save Chhattisgarh from love jihad, religious conversion and people like Akbar, we need people like Vijay Sharma. Do you want Akbar or Vijay? Make Vijay win the elections or else Akbar from Kavardha will take over the whole of Chhattisgarh. Our country does not need any Mughal emperors, Babur, Aurangzeb or Akbar. Our country needs so and so. I am surprised that there is a fear that Babur and Akbar and Humayun will come back. That kind of insecurity, I am quite surprised. Now, just see, these are, in my petition, just note the pages. Graphic 10 instances are given from page. I'll just give the pages. I'll not repeat. I want to show the law in 2 minutes and be done, 2 or 3 minutes.
Yes.
56 to
All
161.
the averments. Averments, I want the averments. I'll just give the averments. Before that, now come to 2 or 3 cases. I'll read only one. Chavan's case. That is State of Maharashtra versus Chavan, 2011, 1 SCC 577.
This is the compilation that you've given.
Yes, case law compilation. Lordship may note, 3 judgments. I'll read only one. Chavan is on, 2011, 1 SCC 577. Then on constitutional morality, Manoj Narula, well-known 9 judges case. 2014, 9 SCC, page 1. They're all in the compilation. And then Jaipur Development Authority, 1997, 1 SCC 35. In a nutshell, they say that constitutional accountability of high constitutional functionaries is paramount.
Yes.
I may just point out the case instead of reading it to save time. These high principles will become mere sermons until your lordships actively operationalizes them. And there cannot be a worse example where it needs immediate operationalization. Now, in this compilation? Well, in the Chavan case, SCC page 589. Para 38 at page 589 of the SCC page.
Just a minute. Which Chaman is this at serial number?
Date of-
Your case compilation index. What is the serial number? We don't find Chaman here.
No, what are you saying?
Five.
Five. Please. Inside 5, para 38.
Which Chaman you said this is
State of
Anish
Maharashtra.
Devgan. Number 5.
9.
Yes. State of Maharashtra versus Sardar Singh, Shivdas Singh, Chavan.
No.
What will you
Number 5 here. Perhaps this is a different compilation that you are referring to.
What is the name of the person?
Number 3, State of Maharashtra versus Chavan. Chavan. Okay. I thought Chaman was the name. All right, Chavan.
So, Malas, in that, just come to para 38.
Page 92.
This being the ground reality as the CM of the state and as holding a position of great responsibility as a high constitutional functionary,
Yes.
Mr. Deshmukh certainly acted beyond all legal laws by giving the impugned directions to the collector to protect members of a particular family who are dealing in money lending business through the normal process of law. This amounts to bestowing special favor to some chosen few at the cost of the vast number of poor people who are farmers, etc., who have come with complaints against torture and atrocities. The instruction will certainly implement. Is completely contrary and inconsistent with the constitutional promise of equality and also the preambular resolve of social and economic justice. Whereas, where is the question of equality if you treat a whole class, as this particular person is doing, as second class, no third, fourth class citizens who don't deserve to be existing?
Yes. Yes, we have seen that. Yes.
Then, Malas, just note, obviously, 3 things in the Constitution. The preamble, where your lordship is familiar with secularism, but not, Malas, we don't use so much more the very important word fraternity. Each of these 2 words cross-fertilize each other. It's a very important word in our preamble. Fraternity.
Yes.
Then link it with Malas Articles 14. Different facets of equality in 15. 19, my right to do work and survive. And 21 above all. Since your lordship is looking at the legal construct, your lordship will obviously see in the BNSS, sections 196, 197, 299 and 353 are clearly implicated. The book is there, I need not, Balas.
Yes, we have not.
Along with Balas, by the way, these are, I don't remember at least the new names, the lordship may be familiar with. They are the old 153A, 153B, 295A, etc. IPC. And Balas, electoral offence separately is clearly made out under 125 of the RP Act. Balas, lastly, we cannot forget the oath of office and what a whole bunch of orders, which will be handed over just now by Mr. Gautam if he is there, by Supreme Court bench 21-10-22 in the hate speech batch of cases. If that may be kindly handed over. It's part of the compilation. My pages are 85 onwards in the compilation, but it's the order of 21-10-22. Give the page.
Page 85 of writ petition.
Page 85 of writ petition.
No, we have that judgment before us. Shaheen Abdullah, you are referring to.
That's right. It's a very, very important judgment.
Yeah. Dr. Singhvi, you are not audible now.
I'll be
From
ending
this moment.
with
Yeah,
this.
now it's all right.
I'll be ending with this, Willis. It is at 88, all the way to Willis, at 88, and in particular 95 and 97. And also Willis 85 and 87.
You're referring to paragraphs, pages.
No, pages, Willis. So 85 at 87. And Willis 88 at 95. That's the correct way to put it. Page numbers. Well, I'm deeply obliged. I am closing by saying, first and foremost, your lordship must have, Willis, a registration of FIR, a complete stoppage in future, at least the damage what had to be done is done, and actual genuine action. I'm deeply obliged, Willis.
All right. Who are parties in your...
May please.
Just a minute, Mr. Singh. We'll
Madam.
get back to you immediately. Who are the parties in your petition? Dr. Singhvi, he has left. Anyway, Mr. Singh, you tell us.
Look, I appear in item 29, that is PIL 14 of 2026.
Yes.
Look, the petitioners are three very eminent members of the civil society in Assam.
Yes.
Dr. Hirendranath Gohain is a renowned author and writer of books who has won the Sahitya Academy Award and various other awards. Very elderly gentleman, very, very deeply resident and a deep lover of Assam, who's spent his whole life promoting Assamese culture and writing about it. The petitioner number 2 is the former Director General of Police of Assam, now also a very senior citizen, who has also post his retirement become a renowned author. He too has won the Sahitya Academy Award and has written several books and all. Again, having been Director General of Police, very knowledgeable about Assam and very deeply invested in the state. And petitioner number 3 is the editor of a newspaper, an Assamese language newspaper called Northeast Now. Assamese language? English language, I'm so sorry. English language newspaper, Northeast Now, which is published in the capital city in Gauhati. All three were petitioners, along with one more person in the Supreme Court. The Supreme Court allowed them to come before your lordships. The petitioners had, in fact, earlier addressed a letter to the Honorable the Chief Justice, but that was more in the nature of an appeal for the Honorable the Chief Justice and the court to step in by way of a suo moto action to restrain.
I remember to have seen that letter and wrote my comment on that also, that nothing prevents the petitioners from approaching the appropriate forum, either filing writ petition or filing whatever.
Deeply obliged. I just needed to...
That was immediately responded to, but it appears you have not been told about that.
No, we didn't know, but that's why we moved the Honorable Supreme Court, and the Supreme Court asked us to come before your lordships, gave us liberty to come before your lordships, and that is how we are here.
That's right.
But,
there was a letter of request which I distinctly remember to have disposed of. I mean, wrote my comment on it.
My lord, but that may have, there is such a huge amount of probably correspondence in the High Court and judicial matters, etc. That probably it may be...
The correspondence, I mean, that one correspondence would be important for the person who has made it. So that was immediately taken note of.
Look, we have no grievance at all on that. We just wanted to point out, as a matter of disclosure, that we had made an effort. The learned Honorable the Chief Justice of India told us that look, there's a difference between an appeal for suo moto action and a direct writ petition. So why don't you adopt the direct means of going by way of a writ petition? Orally, it fell from the court. And it's a point well taken, because suo motu is a very rarely exercised the jurisdiction. It's not every day that the courts would exercise suo motu powers. But having said that, I would just like to join Dr. Singhvi in saying that unfortunately, and it's with great anguish, that these petitioners, at least, who are not politicians, who are not people who have anything to do with one side or the other as far as the political battle lines and so on are drawn. It's with great anguish they come before the court, because they feel that a chief minister of a state is the chief minister of the entire state. He is the chief minister of every last citizen of the state, and not a chief minister of X or Y or Z, or a majority or a minority or anything. After all, he is the go-to person for the entire state. When he gets elected and when he swears his oath of office, he is there to represent everybody without fear or favor, without discrimination, without anything. And this is the anguish which brings these three petitioners before your lordship, that they feel that by a consistent course of conduct, the respondent number 3 in our case has been for whatever reasons it may be, but playing one side against the other and so on, and leading to a very vociferous and a very disruptive or a demeaning sort of situation in the state, and which reflects on the entire state. It doesn't reflect on the minority. Ultimately, every such thing reflects on the entire what we in North India would call the mahal of the state. Ultimately, it denigrates everybody, not X or Y or Z. Having said that, that I would just flag that right from 2023, as we have set out that page 116, 23rd June 23, then on 13 July 23 at page 121. I won't read these letters, but if I can just flag them, there are various very pejorative, very denigratory statements made against Mias. The constant refrain has been Mia Muslims are somehow bringing the state down, and so on and so forth. So I would just ask your lordship to just make a note of it. Page 116, page 121, page 127, and page 131. 116, 121, 127, and 131. And 142 is one of the documents which Dr. Singhvi showed your lordship, which happened in Chhattisgarh. Now, my lords, if your lordships come straight away to 8th of February 2024, which is, my lords, an address to the Legislative Assembly of the state on 8th of February 24, in context of a scheme known as the Mission Basundhara scheme. And in the context of a scheme of the government, which is meant for all the people of the government, the statements made, that page 146, if my lords are kind enough to come to Annexure 12. Now, here is a very a welfare scheme, very well-meaning scheme which is introduced, and this is the report with regard to what is stated. You people can claim to be indigenous if you show your document or identify before you were converted. Then you too will get indigenous status, said the Assam CM in the State Assembly.
Yes.
If you convert, then you will get indigenous status. Assam Chief Minister, Honorable Mr. Sharma, said on Thursday that a person can claim to be indigenous if they show their document or identity before conversion. He was sharing insight on Mission Basundhara in the State Assembly. You people can claim to be indigenous if you show your document or identity. He also asserted that there were some Hindus who were forcefully converted to Islam during the Mughal period. He gave an option and said that these people could return to their originality by accepting Hinduism again, thereby getting their indigenous status back. While on Thursday, the CM was talking about the land allotment and patta distribution to indigenous people of Assam. He cited the definition of indigenous: people who live in a place for years and years are the indigenous people. Aboriginals are the indigenous people. As we say, Red Indians are the indigenous people in America. In this context, he said that anyone coming and settling down in Assam from outside Assam can't be called indigenous. Replying to a counter question of opposition MLAs over the Mia, the Bengali-speaking Bangladesh origin Muslim not getting patta, the CM reacted that Mias came recently, adding even people came to this land Assam 100 years back can't be said as indigenous. He categorically said Basundhara is not for the migrant Muslim. He stated that for the people who came to Assam from other parts of the country, there will be another process. Now, I must explain to your lordships, lords,
Yes.
I must explain to your lordship that this Bangladesh is an issue which is used, unfortunately, very often as a dog whistle. And the reason goes that there's a very deep and old fault line in the state of Assam, and it's a genuine grievance with the people of Assam. I've had for some 200 odd years. When during the British era, some large-scale settlements were permitted, and when the settlement of low-lying lands was given to people from Bengal, that was the unified Bengal of India. And because there was a fair amount of large-scale settlement of Bengali origin people in those days, and when I talk about Bengali origin, not Bangladeshi origin, but Bengali origin in the 19th century, 1860, 1850, 1870, etc. These have all been written about a great deal in Assamese history and all. So there was a ethnic and linguistic grievance, and legitimately so, of people. It was never a religious grievance. It was always an ethnic and a linguistic grievance, because they felt that the British have imposed people from a different culture or different linguistic background on the state of Assam.
Yes. Yes.
Now, when the chief minister of the state says even a person who came 100 years ago cannot be considered as indigenous, he is flagging that sense of grievance, because 100 years ago, India was a unified country. 100 years ago, there was no Bangladesh. And Bangladeshis who entered after 25th of March 1971 are definitely outside the pale. They are not entitled to any protections. Your Lordship's Court and the Supreme Court have made it very clear that those who came afterwards will be treated as illegal migrants. But those who came before that, those who came in 1860, those who came in 1920, 1930s, again, the British had a wave of some settlement in 1920s and 30s. Now, to treat them, and they are the people who are called Mias. Bangladesh is only a dog whistle. All Bengali speaking and Bengali origin Muslims are called Mias. The Bengali origin Hindus are not called Mias. They also may not be accepted as on the same par with others, but they are not called Mias. Mias are only Bengali origin Muslims. So I just wanted to flag this to your lordship, because there's a certain historical background, and my Lord Honorable Justice Chaudhary would be very, very familiar with that, because your lordships have seen this culture throughout your lordship's life. Now, so when these statements are made on a welfare scheme, then this gives your lordships a bit of a background of how this happened. Then your lordship will see on 6th of June 2024 at page 150, statements made in regard to the loss of elections in 3 neighboring states. And the statements made there are to the effect that we have lost these elections because of a particular religious denomination. I'm not flagging these to your lordships as something which is actionable today. I'm only giving your lordship, when I come to today's thing, please see it in this background of consistently. Now, my lords, at page 161, there was a severe flooding in the city of Gauhati, in the area of Gauhati in August of 2024. And at 161, your lordship will see that following that severe flooding, the respondent number 3 made a statement attributing the entire flooding to a college on the border of Meghalaya, and that college, my lords, has been established by a person who belongs to the minority community. And this entire statement was to the effect that there is a land jihad, there is a jihad started by a promoter of a university, and just as there is land jihad, he has started a flood jihad against Assam. And this at page 161, my lords will find. At 162, my lords may just see about para 4, Sharma has pointed to deforestation in the hills in the area as the reason behind the flood, but singled out the institute, accusing it of jihad. He pointed to the ongoing construction work and the work in the campus of a medical college. I think that the USTM owner has started a jihad. We talk about land jihad. He has started a flood jihad against Assam. Otherwise, no one can cut hills in such a ruthless way. He went on, no one who loves nature, especially an education institution, can cut it. I have to call it a jihad. I believe it is deliberate. Otherwise, they can call an architect, etc., etc. And then he says in the second last paragraph, from tomorrow, if the students from Gauhati stop studying and Gauhati's teachers stop going there, then Gauhati's floods will stop. I have given a letter to the Meghalaya CM. I will meet him too, but I don't know how much they can do, but because the damage has been done, etc. Then your lordship will come to the next on 13th of August, a further escalation in this war of words against a university at page 169 on 13th August, after the flash flood was blamed on this university. Now he said that they have created a Mecca over there because they've got 3 domes on a gate, and you have to enter through Mecca to go there. And at page 170, your lordship will just see the top question by reporters on his use of the term jihad. He said they are doing jihador bap, the father of jihad. I'm being mild by calling it jihad. It is destroying our education system. Whatever attacks our civilization, our culture, that is called jihad. So even the medical college is said to be destroying our educational, our culture and our system, etc., etc. Then my lords would see that at page 173, a journalist was attacked on the ground of his religion. And then, my lords, at page 183, again during the Legislative Assembly proceedings, at page 183, my lords, on 27th of August 2024, the Honorable CM categorically said that I will openly say that I am against them. Just see 183, my lords. This is in Assembly. Chief Minister Himanta Biswa Sharma on Tuesday said that he would take sides and won't let Mia Muslims take over Assam. Mr. Sharma was speaking in the Assembly on an adjournment motion brought on law and order issues relating to some rape of a child, a 14-year-old girl. Replying to the motion, he said crime has not increased if the population growth is taken into account. When the opposition charged him of being partisan, Mr. Sharma resorted, I will take sides. What can you do about it? Why will people from lower Assam go to upper Assam so that Mia Muslims can take over Assam? We won't let it happen, he asserted. Now, in this background, and there are several more, but I want to come to today, what is happening since January of this year is very incendiary. It is not just hate speech, but it is incendiary speech, which is aimed at setting a fire and causing disruption in the ordinary harmony between human beings, which is required, which a chief minister should be fostering. So please come now to the current year, my lords, at page 192. Your lordship will see on 25th of January 2026, with regard to the summary revision of electoral rolls, the chief minister stated that notices are being served only on Mias and not on Hindus. And the revision. So your lordship will see this report and scroll. Assam Chief Minister Himanta Biswa Sharma said on Saturday that only Mias and not Hindus or Assamese Muslims were being served notices under the special revision of electoral rolls in the state, reported PTI. There is no controversy over the special revision. The chief minister was quoted as saying by the news agency which Hindu has got notice, which Assamese Muslim has got notice. Notices have been served to Mias and such people, else they will walk over our heads. Mia is a derogatory term for Bengali-speaking Muslims. The ruling Bharatiya Janata Party has often labeled the community as infiltrators who are allegedly taking over resources, jobs and land. On December 27th, etc., the Election Commission, now kindly come overleaf to the next page, let's. About para 4 on Saturday. My lords have the 4th para at page 193, 193 minutes. On Saturday, Sharma stated that there was nothing to hide, reported PTI. We are giving them trouble, said the chief minister, referring to his earlier statement that Mias would face problems in his regime, according to the news agency. He added that serving them notices as part of the special revision exercise was a way to keep them under pressure. They have to understand that at some level, people of Assam are resisting them, said the BJP leader. Otherwise, they will get a walkover. That is why some will get notices during SR, some for eviction, some from border police. Sharma added, we will do some utpat, mischief, but within the ambit of law. We are with the poor and downtrodden, but not those who want to destroy our jati. This came a day after the Assam Congress and Rajour Dal chief filed separate complaints with the police against the BJP for allegedly attempting to tamper with voter lists and so in a complaint and so and so. And then, Lords, at page, this was Lords 193. Now your lordship may come to page 198 on 27th of January 2026. The chief minister stated that 4 to 5 lakh Mias will get deleted in the Assam SIR, and my job is to make them suffer. He says, in the second para, Assam chief minister on Tuesday claimed that 4 to 5 lakh Mia voters will be deleted when the special intensive revision of electoral rolls takes place in the state, and said that his job is to make them suffer. And then he says, vote chori, etc. The third para, he added, we have made arrangements so that they cannot vote in Assam, but this is preliminary. When the special intensive revision comes to Assam, 4 to 5 lakh Mia voters will have to be cut. And can I just read the para above that? What vote chori means to us, Sharma asked while speaking to reporters. Yes, we are trying to steal some Mia votes. Ideally, they should not be allowed to vote in Assam. They should be able to vote in Bangladesh. This time, the pains to point out, this is a dog whistle, because it is not.
Mr. Singh, you have made that point clear. We have read that's all right. But then each and every statement, they don't collocate with the earlier statement. And what vote chori? Why do you call it chori? We are not going to do it. We want to steal votes. These appear to be blusters. Anyway, but otherwise, other statements, of course, you can say, but not every part of it. So there is a physiparous tendency, it appears from your showing. Let's see what they have to say.
Now, just two more letters, if I can show your lordship's notes. At page 202, 202 is very important, because here is an actual call for violence virtually against an entire community. At 202, your lordship will find 27 January and 28 January, the Wire reported that in a rickshaw, if the fare is ₹5, give them 4. The chief minister said, in a rickshaw, if the fare is ₹5, give them 4. Assam chief minister urged people to trouble the Mias. Just below that, Assam chief minister on Tuesday, January 27th, said that between 4 to 5 lakh Mias would be removed from the SIR. He also underlined that Himanta Biswa Sharma and the BJP are directly against Mias, and urged people to trouble the Mias, saying only if they face trouble will they leave Assam. Addressing reporters on the sidelines of an official event in Digboy in Tinsukia, Sharma asserted that it was his responsibility to cause hardship to the Mia community, a term commonly used in Assam to refer to Bengali-speaking Muslims in a derogatory sense. Vote chori means we are trying to steal some Mia votes. They should ideally not be allowed. This is a repetition. On the next page, the second para, your lordship may see, let Congress abuse me as much as they want. My job is to make the Mia people suffer, he said. And then your lordship will see whichever complaints have happened have been on my orders. I myself have told the BJP people that they should keep giving complaints against Mias. There's nothing to hide about this. I have held meetings. I have done video conferences, and I've told people that wherever possible, they should fill Form 7s so that they have to run around a little, are troubled, so that they understand that the Assamese people are still living. If the Congress has objections, so be it. He added, whoever can give trouble in any way should give, including you. In a rickshaw, if the fare is ₹5, give them ₹4. Only if they face trouble will they leave Assam. These are not issues. He said, what is the point of telling us that these are issues? We are saying it openly. We are not hiding it. Earlier, people were scared. Now, I myself am encouraging people to keep giving trouble.
So, Mr. Singh, it's about the same incident. We have seen it. Now, now formulate.
But it's very explicit, the explicit call. And what Dr. Singhvi showed your lordship a video of a rickshaw puller being actually harassed. That came immediately after this. Right after these statements were made, one lady harassed a rickshaw puller and refused to pay him for the... Now, my lords, if your lordships lastly just see, my lords, from 218 onwards, I've set out that same video, but what we did was we set it out in stills. From page 218 to 220 are the still pictures of what Dr. Singhvi has already shown, my lords. Now, my lords, if your lordships are kind enough just to come to my compilation, and I'll very quickly run through 3 or 4 judgments on hate speech, and then the orders which we are praying for, my lords. Yes. If my lord, I have got a brief compilation of some 5 judgments. And my lord may first take Pravasi Bhalai Sangathan, which your lordship will find is at page 6 of the compilation. 2014-11 SCC 477.
Yes.
My Lord, that page 6. Now,
Yes.
Lord, that para 8 of the judgment at page 14, the Supreme Court made an effort to try and cull out what is hate speech in the context of the Indian constitutional scheme. Para 8, hate speech is an effort to marginalize individuals based on their membership in a group. Using expression that exposes the group to hatred, hate speech seeks to delegitimize group members in the eyes of the majority, reducing their social standing and acceptance within society. Hate speech therefore rises beyond causing distress to individual group members. It can have a social impact. Hate speech lays the groundwork for later broad attacks on vulnerable that can range from discrimination to ostracism, segregation, deportation, violence, and in the most extreme cases to genocide. Hate speech also impacts a protected group's ability to respond to the substantive ideas under debate, thereby placing a serious barrier to their full participation in our democracy. Then para 11, their lordships identified that where hate speech intersects with the criminal laws of the country. Para 11, given such disastrous consequences of hate speech, the Indian legal framework has enacted several statutory provisions dealing with the subject, which are referred to as under, and their lordships set out several sections of the Penal Code, the Representation of People Act, the CRPC, the Protection of Civil Rights Act, Religious Institutions Act, etc., which intersect with hate speech. Para 12, their lordship says, in addition thereto, the central government has always provided support to the state governments and union territory administrations in several ways to maintain communal harmony in the country. And in case of need, the central government also sends advisories in this regard from time to time. However, in such cases, as police and public order being a state subject under the 7th schedule, the responsibility of registration and prosecution of crime, including those involved in hate speeches, primarily rests with the respective state government. Then paras 15 and 16 may just be seen at page 16 of the compilation. Sections 153A and 153B IPC make any act which promotes enmity between the groups on grounds of religion and race, etc., or which are prejudicial to national integration punishable. The purpose of enactment of such a provision was to check fissiparous, communal, and separatist tendencies and secure fraternity so as to ensure the dignity of the individual and the unity of the nation. Undoubtedly, religious freedom may be accompanied by liberty of expression of religious opinions, together with the liberty to reasonably criticize the religious beliefs of others. But as been held by the courts time and again, with powers come responsibility. Section 295A IPC deals with offences related to religion and provides for punishment up to 3 years for speech, writing, or signs which are made with a deliberate and malicious intent to insult the religion or religious beliefs of any class. This court in Ramji Lal versus State of UP has upheld the constitutional validity of the section. Similarly, 298 IPC provides that any act with a deliberate and malicious intention of hurting religious feelings is punishable. 295A, etc., etc., etc. Now, if my lord would come to Millard's Amish Devgan, which is at page 20 of this compilation. Now, this was a arising of, I'm sorry.
The provisions are now 196 and 197 of Venice.
Yeah, that's in our prayer.
The same provisions.
Look, these provisions of the IPC have now been replaced.
Just a minute, Mr. Yes.
So, the provisions which are referred to in Pravasi Bhalai of the IPC, etc., are now replaced not in the BNS. And in our prayers, we have not identified all the current provisions also. Now, if my lord would just come to Amish Devgan, that page 20 of the compilation, that is 2021, 1 SCC page 1. This arose from a discharge applications in multiple complaints against a TV personality. Please just come to para 75 at page 85 of the compilation, where the court spoke about the context in which different speakers can speak, and how when an individual or a villager or somebody speaks, it's taken with a pinch of salt. Please see para 75 at page 85. The context as indicated above has a certain key variable, namely who and what is involved, and where and the occasion, time, and under what circumstances the case arises. The who is always plural, for it encompasses the speaker who utters the statement that constitutes hate speech, and also the audience to whom the statement is addressed, which includes both the target and the others. Variable context review recognizes that all speeches are not alike. This is not only because of group affiliations, but in the context of dominant group hate speech against a vulnerable and discriminated group, and also the impact of hate speech depends on the person who has uttered the words. The variable recognizes that a speech by a person of influence, such as a top government or executive functionary, opposition leader, political or social leader or following, or a credible anchor on a TV show, carries a far more credibility and impact than a statement made by a common person on the street. Latter may be driven by anger, emotion, wrong perceptions, or misinformation. This may affect their intent. Impact of their speech would be a mere indifference, meet correction, criticism by peers, or sometimes negligible to warrant attention, and hold that they were likely to incite or had attempted to promote hatred, enmity, etc. between different religious, racial, language, or regional groups. Then kindly come down to placidum, between just 2 lines above placidum D, Millets. Likelihood of similar, about 2 lines above placidum D on that page, likelihood of similar statutory mandate to violence, public disorder, or hatred, when satisfied, would result in penal action as per law. Every right and indulgence has a limit. Further, when the offending act creates public disorder and violence, whether alone or with others, then the aspect of who and the question of indulgence would lose significance and may be of little consequence. Persons of influence, para 76, persons of influence keeping in view their reach, impact, and authority they wield on general public or the specific class to which they belong, owe a duty and have to be more responsible. They are expected to know and perceive the meaning conveyed by the words spoken or written, including the possible meaning that is likely to be conveyed. With experience and knowledge, they are expected to have a higher level of communication skills. It is reasonable to hold that they would be careful in using the words to convey their intent. And then, my lords, that para 114, if my lords come to page 101 of the same report, page 101 of this compilation, para 114 of the same report. In Lalita Kumari, a constitution bench of 5 judges of this court has held that section 154 of the CRPC in unequivocal terms mandates registration of FIR on receipt of all cognizable offences, subject to exceptions in which case a preliminary inquiry is required. The petitioner has not contended that the present case falls under any of such exceptions. Conspicuously, there is a distinction between arrest of an accused person under section 41 of the CRPC and registration of the FIR, which helps maintain delicate balance between the interest of society manifest in section 154 of the CRPC, which directs registration of FIR in case of cognizable offences, and protection of individual liberty of those persons who have been named in the complaint. The Constitution bench, referring to the decision of this court in Tappan Kumar Singh, reiterated that FIR is not an encyclopedia disclosing all facts and details. The informant who lodges the report of the offence may not even know the name of the victim or assailant or know how the offence took place. He need not necessarily be an eyewitness. What is essential is that the information must disclose the commission of a cognizable offence, and the information must provide basis for the police officer to suspect the commission of offence. Thus, at this stage, it is enough if the police officer and information given suspects, though he may not be convinced or satisfied that a cognizable offence has taken place. I'm only citing this to say Lalita Kumari has been followed with, and it's the registration of an offence. Now, your lordships in the Supreme Court have gone further and said that when hate speech is made, especially by responsible people, there is a suo motu requirement by the police to register. There's a mandate that they have to register an FIR. They cannot hold their hand back and wait for a complainant to come forward even. That is if I'll just place straight away the judgments in that regard. Now, in Shaheen Abdullah, which Dr. Singhvi has placed before your lordships, takes that view, and Millards also
that's separately handed over by our colleague.
in Ashwini Kumar Upadhyay.
Yes.
My learned counsel who is present in court will hand up to your lordships was the order in Ashwini Kumar Upadhyay.
2023.
Which is the Supreme Court's order on 13th of January 2023.
Page 8 of the order.
And after a long title, etc., at page 8, it's in our compilation.
It's been handed over to them.
Oh, right. At page 8, your lordship will see where the order begins. Issue notice, petitioner will serve stand. Additional respondent shall ensure that immediately as and when these additional respondent notice had been added on the direction of the court, all states were given notice and had been added as additional respondent. Additional respondent shall ensure that immediately as and when any speech or any action takes place which attracts offences such as 153A, 153B, and 295 and 505 of IPC, etc., suo moto action will be taken to register cases even if no complaint is forthcoming and proceed against the offenders in accordance with law. Additional respondents will therefore issue directions to their subordinates so that appropriate action and law will be taken at the earliest. We make it clear that any hesitation to act in accordance with this direction will be viewed as contempt of this court and appropriate action will be taken against the erring officers. We further make it clear that such action will be taken irrespective of the religion that the maker of the speech or the person who commits such act belongs to, so that the secular character of Bharat as is envisaged by the preamble is preserved and protected. So, and then in Tehseen Poonawalla, that's not in our compilation. Tehseen Poonawalla will be handed up to your lordship's words. Para?
40. This is erosion. It is para 40 or 40.10. 10.
Look, para 30 may kindly be seen.
40.
Sorry, para 40 of Tehseen Poonawalla, which has been handed up to my lord at page 527. Sorry, 525. The directions issued by the court, this arose from lynching, lynching incidents and other mob violence, all kinds of incitement to mob violence. And preventive measures were laid down by the Honorable Supreme Court from page 525 onwards. And in these preventive measures, if my lord would see 40.10.10 at page 526.
Duty of the central government and the state governments.
Yes, it shall be the duty of the central government as well as state government to take steps to curb and stop dissemination and irresponsible and explosive messages, videos, and other materials on various social media platforms which have a tendency to incite mob violence and lynching. And the police shall cause to register FIR under 153A and other relevant provisions of law against persons who disseminate irresponsible and explosive messages and videos having content which is likely to so and so, so and so. And then on remedial measures also there.
Yes.
We need not go into that. And then, my lords, with regard to these sort of statements like what is being done about this jihad, that jihad, etc., kindly just see the order of the Supreme Court in Firoz Iqbal Khan, which is at page 1 of this compilation. There was a series of television programs called UPSC Jihad, job jihad, etc. And at para 11 on page 4 of the compilation, their lordships set out the court is presently seized with hearing of the writ petition, which will continue on the next available date. This was the previous order passed. And then their lordships noted, just see para 11. And if your lordship sees on page 4 of this compilation from Placitum G, there is no relaxation either in the age limit or in so and so. The drift, tenor, and content, last 2 lines on page 4, the drift, tenor, and content of the episode is to bring the community into public hatred and dispute. The court is duty bound to ensure compliance with the salutary principles of the program code. Then para 13 and 14, the edifice of a democratic society committed to the rule of law under a regime of constitutional rights, values, and duties is founded on the coexistence of communities. India is a melting pot of civilizations, cultures, religions, and languages. Any attempt to vilify a religious community must be viewed with grave disfavor by this court. As the custodian of constitutional values, its duty to enforce constitutional values demands nothing less Conscious, therefore, as we are of the previous order dated so and so, declining to issue a pre-broadcast injunction, we are of the view that there has been a change of circumstances, at least prima facie, on the basis of the record which has emerged before this court. On 28th August, this court was truly in the realm of a pre-broadcast injunction when even the first program was to be aired. Since then, episodes have been aired between so and so, which indicate the content, tenor, and object of the telecast in question. The remaining episodes, admittedly, will be in the same vein. On the basis of what has been aired, we are of the view that it will be necessary to interdict any further telecast. Consequently, we direct that pending further orders, the fifth respondent shall stand injuncted for making any further telecast in continuation of the similar thing. So all those job jihad, UPSC jihad, etc., came to be injuncted. And in our petition itself, we have annexed 2 or 3 orders, which your lordship may be kind enough to see, Millards. At page 221 of the main the PIL petition is the order of the Honorable Supreme Court dated 19th May 2025 in Kumar Vijay Shah versus the High Court of Madhya Pradesh. Here, remarks had been made by a minister in that in the state of Madhya Pradesh against the particular lady army officer, and the Supreme Court directed that an SIT be set up at para 3 of the order at page 222. Para 4. Having gone through saying that they were already before the court, having gone through the contents of the statement attributed to the petition and also the contents of the apology purported to have been tendered by him, we are satisfied that the subject FIR requires to be investigated by a special investigation team. Such SIT shall comprise of 3 senior directly recruited IPS officers of the Madhya Pradesh cadre, but who otherwise do not belong to the state of Madhya Pradesh. We are further of the opinion that out of the 3 officers, one should be a woman IPS officer. The DG of police is directly constitute the SIT by 10 a.m. So SIT shall be headed by an officer not below the rank of IGP, and the remaining 2 members shall also be in the rank of superintendent, etc. And then your lordship will see an order which was in the case of a stampede which took place at page 229, the Tamilaga Vetri Kalagam. There was one actor who had started a political party and it led to some stampede, etc. The order is at page 229, but my lord may come straight away to page 248. Para 32 at page 248. Looking to the fact that the issue involves certainly has a bearing on the fundamental rights of citizens and the incident which has shaken the national conscience deserves fair and impartial investigation. As such, by way of interim measure, direction deserves to be issued to hand over the investigation to the CBI, which would lead to fair administration of justice. And then, my lords, at para 33, in the facts of the case and the prayer is made in order to allay the concerns of all persons in pursuit of independence and impartiality of investigation, we propose to set up a 3-member supervisory committee headed by a former judge of this court. We have requested Honorable Justice Ajay Rastogi, who has agreed to head the said committee. We further request him to choose 2 senior IPS officers not below the rank of IGP, who may be of Tamil Nadu cadre but shall not be a native of Tamil Nadu as per the choice of the learned former judge. Scope of mandate of the committee, etc., etc. We are not really concerned with that. And then, that page 224 is the judgment of the Supreme Court in the violence which took place in Lakhimpur Kheri. And at page 226, this order, that 224 was on 7th of November 2021. And at page 226, your lordship will see para 7 and 8. I'm sorry, my learned friend wants me to read para 5 at page 225. This court is equally concerned about guaranteeing an impartial, fair, just and thorough investigation into the incident which has resulted in such a tragic loss of life of protesters. Then para 7, this court in Babubhai Jamnadas Patel has delineated the purpose of the judiciary in such circumstances and noted that the Supreme Court and the High Courts are the sentinels of justice that ensure that the rule of law and constitutional guarantee of a fair and impartial investigation into alleged criminality are upheld on several prior occasions, including in Bharati Tamang versus Union of India, Zahira Habibullah Sheikh versus State of Gujarat. Steps have been taken by courts for monitoring the investigation of alleged criminal offences. While investigating such offences, justice must not only be done, must also be seen to be done. We thus deem it appropriate to reconstitute the SIT to preserve the faith and trust of people in criminal administration of justice, further to assure full and complete justice to the victims of crime, we are inclined to order that the ongoing investigation be monitored by a retired High Court judge who too may not have his roots in the state of Uttar Pradesh. We therefore appoint Justice retired Rakesh Kumar Jain, a former judge of the Punjab and Haryana High Court, to monitor the investigation, etc., etc. So there are, I don't want to multiply it. There are several other orders and so on. If my lords are kind enough just to come to my prayers straight away,
yes,
at page 87, the first three prayers and the last two prayers are more general in nature. And then there are certain prayers which deal with the criminality aspect. But I'm very anxious, my lords, that your lordships take cognizance of the first three prayers in particular, because we are very concerned, Lord, not with securing punishments and so on, but with securing peace and harmony in our state, my lords. We are people who, as I gave in the preface, my lords, we are very, very deeply concerned about a state. One of us is in his late 80s, one is in his late 70s. We have lived our entire life there. We are concerned that we don't want to see our state going up in flames, Lord, that has happened in a neighboring state of Manipur and so on. We want, Lord, peace to be there. So please just see the prayers, Lord, 1, 2, and 3. Mandamus, Lord, directing respondent 3, the agents, etc., to completely refrain from indulging in speech that instigates the social or economic boycott of any minority community in Assam or driving out of any minority community from Assam. Issue an order directing respondent 3, etc., to completely refrain from inciting civilians to take law and order into their own hands by acting against persons perceived to be of a minority community. Mandamus Lords to completely refrain from indulging in speech that promotes enmity, hatred, and ill will towards a community based on religion and language. Now, 4 and 5 are, my lords, with regard to criminal. 4, 5, and 6 are with regard to, my lords, criminal investigation, where we are seeking, my lords, we are praying that the court may, after notice, of course, constitute a proper SIT, my lords, headed by a retired learned judge, and with some sort of guarantee of impartiality, which is under the supervision of the court.
Yes.
Now, please see prayers 6, Lord, 6 and 7, Lord. Issue a declaration that respondent 3 has committed a violation of the oath of office under Article 164(3), read with the preamble. The oath of office we have set out, Lord, at page 48 of our petition. And Lord,
this I'm sure you'll say only after notice.
Certainly after notice, Lord. Today we are really praying, Lord, that your lordships issue notice and that my lords give some indication that this must stop. This can't go on, Lord. We are facing a very distressing situation. I can't say anything more than that. It is exceedingly distressing that, Lord, the head of the state has such great responsibility to serve all the citizens of the state should pick and choose between citizens. It's just very, very distressing, Lord, to use demeaning language, to denigrate people who are, after all, we are all, every single citizen of the state has an expectation from our chief minister.
All right.
Yes. So, Lord, the interim prayers are set out, Lord, at page 90.
Let's hear out.
My lord. Well, I just could flag that, page 90 of the interim prayers. I'm deeply obliged, Lord, for a very, very patient hearing, Lord.
My lords, I'll be very, very brief because a lot has been said by my learned colleague and before that by Dr. Singhvi. So I'm not going to repeat most of it. Now, a lot of statements that have been read by my learned colleague are also in my petition, which is PIL number 15. I'm not going to read any one of those again, which have already been read, save and except to say that if my lords were so kind and please turn to these statements beginning at page number 58. And I'm not going to read them extensio, but I want to show certain dates and I have an argument on that. Well, was my first statement that I annex at annexure P2 at page 58, where Barack Obama had made certain statements that India may pull apart if rights of religious and ethnic minorities are not upheld. The CM had a contra remark to make, a rather ugly one, if I may say so, but this is a statement of 23rd June 2023. What I'm going to lead my lords to see here with me is that there is a consistent pattern here in making statements, observations against a given community throughout. And this is not something that's happening in the middle of the elections, as sometimes can be said, oh, this is a part of the election fervor or something of the kind. No, there is a pattern here. There's a consistency here. And that particular pattern and that continuous statements made over a period of time against a particular community, I would say, go against the very framework of the preamble of the Constitution and the rights under the Constitution. So just give me 2 minutes. I'm not going to dilate. I'm going to be as fast as possible. Now, my lords, this was the first one, is dated 23rd June 2023. Now, would my lords may please turn to page number 61. The community, and with the derogatory term MEAs, my lords, it's very unfortunate because the word is used in a manner which otherwise may have been at one time used with some degree, but it's now given a color of a derogatory nature. And now he says he blames so-called quote-unquote MEAs for rocketing of vegetable prices. And this is a statement made on 16 July 2023. My lords, have page 61.
Yeah.
And if you would just turn over the page, this is an incitement at bottom of page 61 and top of 62. And I am citing this particular 3 lines to say that as a head of a state, as a chief minister of a state, or any person who occupies a position of power, responsibility, cannot make some remarks which can lead to a law and order issue or which will result in leading certain members of any other community to follow him and to take law into their own hands. So what does he say here? He says, MEAs in a prerogative firm responsible for high prices of vegetables in Gauhati issued a call for the state youth to come forward, take up job in order to clean Gauhati from MEAs. My lords, I would ask myself, what do you mean by clean Gauhatis of MEAs? A remark of the leader which was termed as derisive. Now, my lords may please turn immediately to page number 64. Then there's a speaking statement that we don't need the MEA votes for 10 years. We are good with that. I will leave that. Let me go forward on this one. Would my lords now please turn to page number 84. This is now October of 2023. We are still in 2023. Then there's 24, there's 25, and the latest what my friends have read. I'm not going to read them all over again. So, my lords, in 2023, in the election campaign in Chhattisgarh, there is a huge amount of derogatory statements made against a particular community in Chhattisgarh. Please see page 85. Please see the fourth paragraph from bottom in controversial speech. My lords, have that?
Yes.
Yes. In controversial speech in question, Sarma appealed to voters to remove Akbar, saying, if one Akbar comes, he brings 100 others. एक अकबर अगर एक जगह आते हैं तो वो 100 अकबर को बुलाकर लाते हैं. ये बात भुलाए मत. इसीलिए जितना जल्दी हो सकता है अब वो अकबर तो आप विदा कीजिए, नहीं तो माँ कौशल्या का भूमि अपवित्र हो जाएगा. My lords, we are inciting here a complete religious thing, which a chief minister cannot do in a secular country. At the end of the day, our preamble still has a secular provision. It's not that that has gone. In a secular country, one cannot use a religious ground either to invite vote or to put down any other religion. Then, my lords, he says we don't need MEA votes for 10 years. Now, it carries on. The next document, Election Commission gives him a notice, but my lords, nothing really has happened. If my lords will come a little bit forward, I won't show you many more of those in 2023. We can straight away now go to his statements in 2024. And what I'm trying to show is that there is a consistent pattern that is there in this thing to over the years only to denigrate a particular community. My lords may turn to page number 96. 18 July 2024. My lords, I have left some in between. I'm sure my lords have heard enough from my learned colleagues. There is no need to show. Now, this is on population business. Now, 18 July 2024, Opposition parties in Assam on Thursday accused Chief Minister of diverting people's attention by pressing problems by making claim that Muslim population in the state has risen to 40%. Sarma claimed in Ranchi on Wednesday that Muslim population in Assam had increased to 40%, adding that demographic change is a big issue. Then this is his statement that he made in Chhattisgarh. I come from Assam and demographic change is a big issue for me. Muslim population in my state is 40% now, which was 12% in 51. It is not a political issue for me, but a matter of life and death. So, my lords, these are statements which are not supported by any material. They are not supported by any statistics, nothing. They are just made to incite and to make people act in a particular way. Then, my lords, please see then the flood jihad, which Mr. Chandaruday Singh read in detail about that educational institution. So he encouraged people not to go to an institution because it had a Bengali Muslim origin. An institution set up by a Bengali Muslim origin. So the students from Assam should not go, and the floods in Assam will stop if they did not go to that institution. My lords, I ask myself a question. If these are not incendiary, if they are not inciting people to act in a particular manner, what else are these particular speeches? How does a flood stop whether students go to a college or do not go to a college? So these are the kind of statements. Then, my lords, he goes on in 2024 again to say that going to an institution is like going to Mecca because it has a particular structure. My lords, the thing is, when he is questioned, now come to page 106, please, with me. In a meeting, he is questioned by a Muslim journalist, Shah Alam. My lords, have page 106?
Yes.
Sarma on Wednesday, August 21, derided Shah Alam, the reporter, for his religious identity over a question about raising and cutting of hills reported from Sarma's Jalukbari Assembly constituency. So, my lords, in the case of an educational institution, it was another constituency, another place where the institution had been built. When questioned about his own constituency by a Muslim reporter, this is what he says. CM rebuked the reporter over his religious identity after the reporter asked a question on hill cutting in his constituency, Jalukbari. Sarma asked him whether they, that is Muslims, will allow them, that is Hindus, to live in Assam, citing demographic change. Well, how does a journalist's religious identity have anything to do with his profession, or which is a part of his work, to ask a question of a chief minister? And because the reporter comes from a particular community, he is derided rather than to answer a question. So, my lords, this, if you would find 2024, next is 111, and it carries on. Others have been read in extensio. Then, my lords, the same thing happens in 2025. Similar statements, my lords, will find here at page number 113 in 2024. And then, my lords, here in 2026, which are completely vitriolic, if I may say so the least, at 116. And now, in 2026, there is a categorical campaign to trouble the Muslims so that they will face problems and they will leave the state. My lords, if this is not inciting, then what else, I would ask myself, would be the question. Because it's categorical statement: give them trouble, do not give them jobs, or do not pay them the fare which they are entitled to legitimately. We will do some mischief. Calls it within the ambit of law, but understands, recognizes that we will do some mischief. My lords, there's only one more that I wish to read, and I will not read further, and I'll come down to my legal proposition right away. Would my lords please turn to page number 124 of my compilation?
Yes.
Please come to the last paragraph in that. Let Congress abuse me. My lords have that. 124, 125. Let Congress abuse me as much as they want. My job is to make Mia people suffer. He said, reiterating an earlier remark that BJP-led government would create utpad, disturbances. My lords, please come to page 125 to the second paragraph there. He added, whoever can give, my lords, mark the word whoever, can give trouble in any way should give. He's inciting everyone and all from the state to go ahead and trouble the Muslim population in the state, including you. In rickshaw, if the fare is 5, give them 4. Only if they face troubles, now mark those words, they will leave Assam. These are not issues. So and so, my lords, will leave that. And then, my lords, when a complaint is filed against him, please turn to page number 128. I have already read his quotations on giving trouble to the community, but there is one more here at 128, which is earlier too. Sarma had said that his government, my lords may mark that word please, would continue to disturb the Miyas and tame them down. My lords, I would ask myself the question, what is the purport and intent of making these particular statements if that is not to incite? Now, on a very, very brief position that I place this matter on, my lords, I mean, it's carrying coal to Newcastle, but my lords, our preamble says that we are a sovereign, socialist, secular, democratic republic, and to secure to all its citizens, now I'm reading the ones which are relevant here, social, economic, justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship. My lords, completely the fundamental right. And then, my lords, opportunity, equality of status, of opportunity, and promote amongst them all fraternity. My lords, I would put this, that in the orders which my learned colleague Chandra Uday Singh just read from Shaheen Abdullah and Ashwini Kumar, this is the kind of order that I'm requesting and I'm praying my lords to issue. In Shaheen Abdullah, my lords have that order, and I think that compilation was passed on to my lords. The Supreme Court held thus, my lords, this is an order passed by Supreme Court on 21st October 2022. And if I may just read from Shaheen Abdullah, we feel that this court is charged with the duty to protect fundamental rights and to preserve the constitutional values and the secular democratic character of the nation, in particular, the rule of law. So having made that particular statement on a legal position, where in case of such statement, speeches being made, the matter needs examination in some form of interim directions. The court issued notice and then it directed thus. Commissioner of Police, New Delhi, respondent so-and-so Uttarakhand, Uttar Pradesh, to file a report what action has been taken with regard to such acts as are subject matter of this writ petition within their jurisdiction. Then respondents 2 to 4 will ensure immediately, as and when any speech or any action takes place that attracts offences such as 153A, 153B IPC, which of course will be now under the new code, suo motu action will be taken to register cases even if no complaint is forthcoming and proceed against the offenders in accordance with law. Respondent number 2 to 4 will therefore issue direction to their subordinates so that appropriate action in law will be taken at the earliest. So the Supreme Court passed these orders in the matter of hate speeches, just as the one that I'm reading to my lords just now. There is one other order of the Supreme Court, and I will only read the relevant portion. My lords, Ashwini Kumar Upadhyay versus Union of India, and that is an order of the Supreme Court dated 28th of April 2023. I take it, my lords, that my colleagues there have passed over a copy of that order. My lords have that. I'm grateful. Would my lords just look, my lords, there's a very long post title. I mean, yeah, there are appearances running over 2 pages, etc. Please come to where the order of the court starts. My lords, please look at that. Look at the paragraph after leaving the first paragraph, the second paragraph of the order. Respondent number 9 to 36 will ensure that immediately as and when any speech or action takes place which attracts offences such as so and so, suo motu action will be taken to register. So the Supreme Court repeated what it had directed in Shaheen, and then Respondent number 9 to 36 will therefore issue directions to their subordinate action so that appropriate action in law will be taken at the earliest. We make it clear that any hesitation to act in accordance with the direction will be viewed as a contempt of this court and appropriate action will be taken. Now, my lords, I take this next paragraph as very serious, this thing directive, and that is the plank on which the Supreme Court issues these orders. We further make it clear that such action will be taken irrespective of religion that the maker of the speech or the person who commits such act profess, so that secular character of India, that is Bharat, as is envisaged by the preamble, is preserved and protected. My lords, I implore that, given the fact that we have a person who is a leader of a state, but without impunity, has been consistently making these kind of statements, and I have placed before my lords right since 2023. So therefore, the character of a person to make these kind of statements is now well established. And the statements are of the nature that incite a particular community to act in violence, in derogation of law and order against another community, which directly has an effect on law and order in a given state. My lords, these statements definitely are required to be viewed very seriously. I would request, my lords, that there must be a direction in the nature of Shaheen and in the nature of Ashwini Upadhyay, as has been prayed, to register at least the FIRs. They are required to be registered and necessary action is required to be taken. And in the interregnum, my lords, it will be my humble prayer to my lords that there must be a direction to the respondent to cease and desist from making such statements which will have an impact of having issues of law and order, violence, incite a young generation to think in a particular way which is not in keeping with our constitutional values or not in keeping with our constitutional morality. My lords, I rest my case on that.
Lord, I'm sorry if I can just take 1 minute, Lord. I've missed placing before your lordships the judgment just 1 week old of his lordship, Honorable Justice Ujjwal Bhuyan. Lord, if I can just ask my learned counsel to hand it up to your lordship. Lord, this is the judgment of the Supreme Court in Atul Mishra. And Lord, the matter was settled
that name of the film
by a statement made, and then Lord, Justice Bhuyan's judgment begins at page 5 of the report. His lordship gave a separate judgment because he felt it was so important to stress certain issues regarding fraternity. Your lordship will come at page 10, Lord, as a heading of fraternity. Para 11 onwards. Now just come to para 13, my lord, because this stemmed, my lord, Justice Bhuyan's view stemmed from the section 6A judgment of the Constitution Bench on Assam, on the arising out of the Assam Accord. If I can just read para 13. Recently, a Constitution Bench of this court in Citizenship Act 1951, section 6A in re, was examining the challenge to the constitutional validity. Now, coming down, Lord, in that same para, on page 12, about eight lines from the top, it was also argued. This is very important. It was also argued by the petitioners that the influx of illegal migrants from the specified territory is Bangladesh, into the state of Assam had jeopardized the very ideal of fraternity in India, inasmuch as the constitutional mandate in the preamble pertains to fraternity among citizens, and that this notion of fraternity might be destroyed when a legislative enactment like Section 6A threatens to destroy the cultural demography of that citizenry. It was in that context that the Constitutional Bench, speaking through Justice Suryakant, as the Honorable Chief Justice of India then was, analyzed the meaning of the expression fraternity to determine as to whether 6A violates or reinforces the idea of fraternity. This court observed that the term fraternity as articulated in the preamble embodies a sense of collective brotherhood amongst all Indians. Adverting to the Constituent Assembly debate, this court opined that fraternity assumes paramount significance in reinforcing the ideals of equality and liberty, both of which are integral facets of the preamble. Fraternity serves as a critical element for national unity. Kindly come to para 13.4. On page 14, the idea of fraternity was therefore envisioned as a deep sense of well-being for others and understood as essential to counterbalance individualism, thereby preventing anarchy and sustaining moral order. Dr. Ambedkar's introduction of the term fraternity into the constitutional preamble reflects his persistent efforts towards eradicating caste discrimination, his advocacy for unity and brotherhood, which mirrors his commitment to inclusivity. Unlike the West, in India, fraternity is distinctly perceived as a vital instrument for realizing equality and harmonizing the diverse segments of society. It serves as a conduit for transcending societal disparities and working towards collective well-being. Therefore, in the Indian constitutional context, fraternity assumes a dynamic and inclusive role, aligning with the broader goals of social justice, equality, and upliftment. Now, I'm stressing para 14. It is therefore constitutionally impermissible for anybody, be it the state or non-state actors, through any medium such as speeches, memes, cartoons, visual arts, etc., to vilify and denigrate any community. It will be violative of the Constitution to target any particular community on the basis of religion, language, caste, or region by whosoever he or she may be. This is particularly true for public figures occupying high constitutional office who have taken the solemn oath to uphold the Constitution.
Yes.
So, I just want to stress one thing, because somehow an impression seems to have been gathered that the 6A judgment makes it sort of an open field to say whatever you like against Mias and so on. The 6A judgment rejected the argument of the petitioners that there has been a demographic change or there's a threat to demographic change in Assam, and all was rejected by the Supreme Court, saying that there is no such threat. 6A cannot be challenged on the ground that there has been any threat to the culture and of Assam. So I just want to place this, that this is the Supreme Court speaking just 1 week ago on 19th of February, and sorry I missed placing it earlier.
That's all right. That's all right. We were aware of this judgment. In PIL number 15, who all are parties? MS
Yes,
Arora?
please, my lords. Please, my lords. My lords, it is Union of India, state, and the. My lords will find.
We get it at page number?
My lords will find it page number 3 of my petition, my lords.
PD 36.
Page number 3, my lords. Page number 2 and 3 is the cost.
In PIL number 15, let notice be issued. We have heard so. Let notice be issued to the respondents. Notice to respondents number 1 and 2 is accepted by any state council here.
Yes,
Notice to respond number 1 is accepted by Mr. R.K.D. Chaudhary, learned Deputy Solicitor General. And notice to respond number 2 is accepted by MS R.B. Bora, learned advocate for the state. Let notice be issued to respond number 3 on steps being taken by the, you send a notice on steps being taken by the petitioner within a period of 2 weeks, both modes, returnable. We'll fix a date, returnable. We'll see the date from the calendar.
No, then PL 14 also your lordships would.
Yes. We are proceeding from the backwards. I mean, the case which is because we have the files like this.
My lord.
In PIL number 14.
Look, at page 4 are the respondents.
Just a minute. Let's have that page.
Page 4. Page 3 are the petitioners. Page 4 are the respondents. Union of India, State of Assam, the Honorable Chief Minister, and the DG Director General.
So, notice to respond number 1 accepted by so and so, 2 by so and so, 3, 2 and 4, and for 3 again steps to be taken by you. Steps taken within 2 weeks, returnable. Both modes you'll issue notice.
My lords, can we make a request for a fairly short returnable date? My lords?
We will. 2 weeks we have given you time, and 3 weeks further, so that makes it 5 weeks. We are keeping it in April.
My lord, because the Honorable Supreme Court had requested my lords to give it some priority if possible.
That's right. Therefore, we heard it today only. It was mentioned yesterday. We have heard it today.
We are deeply obliged for that. But could you consider keeping it perhaps in March, sometime late in March?
This is in compliance of the Supreme Court's judgment, the directions.
No.
Also
Supreme
the
Court only makes the
responsibility-
request. No, Supreme Court only makes the request, nothing more. No.
And the responsibility of this court as well, the emergent necessity. Let's see. This is PIL number 16. Who would tell us the page number? Mr. Singhvi has exited. Page number 2 and 3. Respondents number 2.
Yeah.
We'll just come to that.
So here the notice to respond number 1 by Mr. R.K.D. Chaudhary. State of Assam 2 is also, this is State of Assam, R.B. Bora, Bharatiya Janata Party. I don't think it's necessary. Let 3 be like this. We are not issuing any notice to party. And Mr. Any representative of Dr. Singhvi here? No need of notice to BJP?
Please, my lords. My lords, BJP has been added as a party because the video was released on the official handle of the BJP, that BJP Assam Pradesh. So it's only fair to.
All right, we'll consider it later when we get the response. And number 4, you also file notice. Mr. Singh,
We are praying for an ad interim order in terms of of the interim orders, only to refrain from such speech.
That's right. Mr. Singh, you would agree that without notice, without the person being represented, that would not be appropriate. We shall see. And it will be a normal restraint when this writ petition is pending consideration.
Then I appreciate notice on interim relief may be indicated so that
notice on the main petition as well as the interim relief. Yes.
Deeply obliged.
Very grateful for a very patient hearing, my lords.
All the 3 petitions. It was good to hear all of you after such a long time.
Very grateful to
Ms. Arora, I had been hearing her since 2015. Dates and do we keep it after Bihu, because there's a whole lot of long holidays in second week of April?
Please, Your Lordship.
Please, my lord, what's convenient to the court is all right.
Immediately after Bihu.
Very well.
All
right.
Very obliged.
21st April.
Yes. Followed the next one.
Item 22. Item 22.
Now,
Yes, my lords.
We'll rise for a minute again. Now let us forget the facts of these cases. Yes, we were. Mr.
Item
Sagar, you
22.
can continue,
My lords.
but be brief.
Yes, my lord. I'll try and be brief. Yes, my lords. I believe, my lords, we were on the issue of why the appellant had taken out his service book, my lords. My lords, in regard to this, I have a colleague of mine who will pass over a document, an RTI reply, which we have sought for from the DPNAR, my lords.
I think you give a copy to the Council for the Mizoram.
My lords. My lords may come to page number 11.
You had to give a copy to her also, no? MS Bhattacharya. You have kept only 2 copies. Now, how can we see it when the other side does not see it?
I apologize for that. I thought
Anyway, we give 1 copy.
I thought we had sufficient copies, my lords.
Yes, page
I
number.
apologize for the inconvenience, my lords. My lords may come to page 11. My lords, the second paragraph, if I may read it, my lords.
Second, which?
The sentence starts as above and with no malice in mind, my lords. Page number 11, my lords.
What is this document that you have passed on to us?
My lords, this is an RTI reply which we have sought for from the
No, no, this she has given us a wrong copy of the article of charge.
My lords, I think that is the correct copy of it.
That's all right. So what do you want to refer to?
My lords, in this RTI reply, I have submitted my written statement with regards to the departmental proceeding which was initiated against me in the year 2016, my lords. And this written statement, this particular written statement starts from page number, it starts from page number 10, my lords. This is on 16th May 2017, my lords, this written statement.
Yes.
My lords, page number 11, my lords are there?
Yes.
My lords, if I may read, as above and with no malice in mind, the undersigned had called for a service book, not the government copy, and it was supplied to the undersigned from Engineer-in-Chief Office, and the same was kept in the safe custody of the Chief Engineer, Rhodes, who was his head of office at that point of time and was still in that office till the undersigned took it out after the multiple demands to return the same was received from the government. That's the service book of the undersigned was in the custody of the head of the office, and the same was not at all manipulated by the undersigned at any point of time by way of changing the year 1957 to 1960. And hence, the said alleged allegation of tampering of the undersigned's date of birth in the said service book cannot stand the test of law against the undersigned at any circumstances whatsoever. And if I may go to para number 4, my lords. Point number 4.
Yes.
That's the service card of the undersigned, which is kept under the custody of Director of Accounts and Treasury's Government of Mizoram Aizawl, in which my date of birth is reflected very clearly and cogently as on 18/10/1960, which itself clearly proves that there was no tampering of such entry in the service card till the end, and this fact clearly and amply proves that my said date of birth, 18/10/1960, is the actual date of birth, and as such, my date of birth can never be made as on 10/10/1957 or 18/10/1957 instead of my actual date of birth, 18/10/1960. Now, my lords may come to my lords may kindly come to the first page of the RTI reply, my lords.
Yes.
My lords, point number 6 and point number 7 are very important in this reply, my lords. Point number 6 states that inquiry report was not received from the inquiry officer. And point number 7, order was not issued in connection with the department proceedings, my lords. Now, my lords, what I would want to stress on this point is,
Show us what is the report of the forensic experts.
my lords, that is on page number 138 of my writ appeal, my lords.
138.
My lords, it starts from page number 138.
Yes.
Page number 138 is the examination report for the service book, and page number 141 is the examination report for my service card, my lord.
Please read the examination report and findings.
My
At
lords,
page
I will go to
138.
the reading, my lords. The question writings marked here as Q in the service
That's
book.
all right. We have followed that. Examination reports.
Okay, my
Next
lords.
paragraph.
My lords, it is found that the existing date of birth figures and word found in the service book of John Ramoya, marked here as Q, is not the original word entered at the time of entering the service book. After careful examination of the suspected area marked here as Q and other handwriting with the help of the above mentioned scientific equipments, it is observed that the writing ink showed different in tint and luster. Also, execution and formation of letter E, shoulder of letter H, and N formation of outward beginning of letter D are all found different in the suspected area with other handwritings in the service book. All the above mentioned writing characteristic dissimilarities are significant and sufficient to come to a definite conclusion, my lords. Now, my lords may kindly come to page 141, my lords.
One second, page 139.
139. That is a copy of my service book, my lords. My lords, a simple glance at my service book, a copy of this service book would show that there is no striking out or erasure into the in my service book, my lords.
इसको 57 कर दिया है। The term इसको 57 कर नहीं, ये नहीं लग रहा है। 1960 दिख रहा है, तो ये कहता है कि हमको यही 60 रहने दीजिए। 57 सरकार ने कह दिया because ये there was something. And where from did they get that number? Did they get that?
1957, my lords.
Yes.
This is from my ACR dated way back in 1983, my lords. All this has manifested from my ACR way back in 1983, my lords. Page, which my lords may find at page number 143, my lords. Page number 143 of my writ appeal, my lords.
Yes.
My lords, this is form of confidential reports. This is for the year 19.
When you had joined the service? You had joined service when?
I had joined service in the year 1981, my lords.
Yeah, yes, 19?
1981, my lords.
1981. It was shown as 1957. When did you come to know about it? It must have been communicated to you.
My lords, this was, and I have also submitted a representation, a complaint regarding this as well in the year 1987, which my lords may find on page number, in my additional affidavit, which we have placed on record before this honorable court, my lord.
And what is your response to this, that your younger brother was born in 1959?
My lords, this is nothing but mere conjecture on the part of the state respondents, my lords.
Now, where have you denied that?
My lords, I have placed on record my date of birth, my birth certificate as well, and I have during the course of my submissions before the honorable single bench, my lords, that my date of birth is younger than the date of birth of the concern of my
Your brother, your
my
younger
lord.
brother also was in service. Was he or was he not?
My lords, he was not my younger brother, my lords. This was a conjecture and an assumption.
You have denied that.
Respondents, my lords.
Where have you denied that?
My lords, this was raised by the state respondents in their affidavit in opposition, my lords. And
That's
during
right.
the course
But
of the hearing,
have you denied that?
yes, my lords,
you
I
don't
have
have a brother who is younger to you.
during the course of the hearing before the honorable single bench, my lord, I have
Therefore, Mr. Silo, you mean to say that the somebody who has been shown as your younger brother, he is a fictitious person. Is it correct?
My lords, the younger brother.
We understand. Don't get exasperated, Mr. Silo. We understand.
My
The
lord.
first entry in the service records, every school certificate says 1960.
My lord.
You perhaps felt ambushed when later the payslip stated that you are 1957 born. And
My
then
lord.
this whole idea erupted that your younger brother retired. He also was in audit service. He retired in 1959.
My
Therefore,
lord.
you could not have been born in 1960.
My
So
lord.
do you say that, see, we understand all that, we are conscious of the law position and we are also conscious of the date of birth and any alteration therein.
My
You
lords.
tell us one thing, whether the name of that person who is shown as your younger brother, is he a fictitious person or he is somebody who may be existing but he is not your brother?
He is existing and he is my brother, my lord. But he is not my,
Because
my younger brother, my lord.
we are contemplating of, see, otherwise it would have passed off.
My lords.
1960. But once it is found that your own younger brother retired in 1959 from central government service, then
My
it will
lord.
be very difficult to keep a blind eye to this.
My lords.
Normally, the certificate is necessary. I mean, the certificate which the school leaving certificate, the matriculation certificate, your entry in the service record, everything is 1960. You are happy with 1960.
My
It is
lord.
the government which is doing it. So
My lord.
let's see what MS Bhattacharya has to say.
My lords,
We might consider issuing notice to the person to say and depose that he retired. We'll see his records.
My
And
lords,
then
if I
we
may,
will
if I
ask
may
you
put
whether,
across one important point again, my lords.
that's
If I
the
may
most
put
important
one
point.
important point before
All
you,
other points are in your favor. All other points except the judgment against you by a single judge, everything is in your favor.
my lords,
Except one,
What-
because once an idea,
my lords.
trickles down,
And
that
my lords,
you have
one
made a
very
wrong
important
statement.
point. One very important point, my lords. My lords, one very
Let us be satisfied that that man is your younger brother. His date of birth is 1957. His date of birth is 1959. He has retired. He never questioned it. Now let's
lord.
have another factor in mind, and then we decide. Otherwise, we are finding this whole exercise by government of Mizoram to be wrong.
My lords. And one very important point, my lords, if I may.
What else do you want us to say except
lord.
one important
My
point,
lords,
the other
I'll be
important
quick
point?
with it. I'll be short with it, my lords.
We are even doubting the correctness of the forensic science report, even though we are not experts.
My lords.
There is not a single overwriting or something that we can identify by our naked eyes.
My
So
lords.
all this we are observing in your favor, but once this aspect has come, should we leave it unattended? Should we close our eyes to it, or should we further verify? Within 2 weeks, it will be verified. And in that case, you'll have to retract, or you will become more vehement in your submissions.
My lords. My lords.
Let's see what Ms. Bhattacharya has to say. Yes.
When he joined, the date of joining, he is not 21 years. Because as per Mizoram service rule, he has to 21 years of age at the date of.
When did he? That is a ground. When did he enter the service? Look at this. Another point was Mrs. Bhattacharya. This has not been gone into by the learned single judge. Nonetheless, we can take judicial notice of this. So, forget about the affidavit. It was not questioned. You never pressed it. Now he entered into service when?
10/3/1981.
10/3/1981. Which service was this?
Lordship,
Which service was this?
That is that Mizoram engineer that PWD engineering service.
PWD engineering service, PWD in the state of Mizoram. Now he needed to be 21 years on the date of entry. Now if it is 57, if it is 1960, then he is just 21.
That's 21, Lordship.
So
Below 21.
his date of birth is?
Date of birth as per 18/10/1960.
18/10/1960. So he would have become 21 in the month of October 1981.
He joined in the month of March.
Yes. And where did you find his younger brother having?
That is the document, Lordship.
How did you get it?
Lordship. There is a government document from website we have got, Lordship, because I have made a statement in my.
And Mr. Silo has not denied it.
Not denied, Lordship. That is also mentioned in the judgment.
Now tell us, Mr. Silo, do you want us to again send notice to your brother and trouble him?
My lords, we are ready for that. And if my lords find it.
Tell me with this fact. We were not conscious of this fact.
My
You were
lord.
not even 21. When you entered service, you were not 21.
My lords.
The only answer which you can give is that the government, the department did not look at this, and therefore it passed off.
My lords.
They were in a hurry to appoint me, so they have
My lords,
appointed.
if I may put across a point, my lords. I was the first graduate of IIT Delhi who had joined service under the Mizoram Engineering Service at that point in time, my lord.
You may be graduate of Delhi or Massachusetts. It doesn't make any difference. If these facts cannot be doubted, see, your background will not give an impression that you have not made a wrong statement in your service record. That cannot be anticipated. Now, people with great background also do what we don't know. We can't assume such, that it would be very naive to say this. That since you are very well educated, you would not have lied about your date of birth.
My lords. There are provisions for relaxation as well, my lord.
You please answer this. You would not have been 21 on the date of entry in service. What do you have to say to this?
It was just a matter of a few months, my lords.
But then where is the decision to waive that. When
My-
you
I
might
have
not be
been
of
appointed
age
to
to
that-
apply also. No.
I have been appointed to the post of junior engineer, my lords.
Look, we could have ignored this aspect that your brother was, younger brother was born.
He's maybe incorrect.
His date of birth also may have been incorrectly entered, we don't know. But this catches our attention.
My lords.
Take that.
Yes, sir. ये देखिए, single.
Page of 16, Lordship of the Judgment.
My lords, if I may. If my
That's
lord.
all. I think we have given you ample hearing. We don't think with this fact having been brought to our notice, we don't find any reason to interfere with the single judges.
My lords, if my
Now
lords.
that you've retired, be happy.
If my
Don't,
lords may
we
kindly,
will not question it.
if my lords may kindly give me a moment, my lords.
Yes.
I would like to put across one very important point, my lords.
Yes.
My lords may kindly come to my RTI reply again, my lords.
Then forget about it. We are not concerned.
My lords, if
We'll base our decision on this.
my lords may kindly bear with me, my lords. My lords may kindly come to page number.
Yes, yes.
May kindly come to page number 2 of the RTI reply, my lords.
Yes.
This is the memorandum of charge which was served to me, my lords. This is dated 17/2/2017, my lords.
We are not going on that.
My lords, what
Just
is
a minute. Just a
My
minute,
lord.
Mr. Silo. You would not be required to argue this for the reason that we have told you upfront that with this fact in our mind, we are going to dismiss this appeal. But the reason would not be your reply or the report of the forensic expert. Nothing. We are not doing that. In
My
fact,
lord.
that gives you an upper edge. We were inclined to reverse the order of the land single judge. But this weighs heavily with us.
my lords?
So therefore, you need not take us to that RTI or the disciplinary proceeding or whatever. No.
What I'm trying to put across is that the order dated 17.
By now you have retired or you're still in service?
I am retired, my lords.
Oh, leave it.
My lords, the order which has changed my date of birth, issued by the government, by the state respondents, was issued on the very same date that this memorandum of charge was served to me, my lords. My lords, no reasonable opportunity of being heard was afforded to me by the state respondents, my lords.
We'll say that the government of Mizoram handled this matter recklessly. Nonetheless, you have now retired, and we have good reasons to believe that you were 1957 born and not 1960 born.
My lords, where does that, there is no document to show that my date of birth is 1957, my lords.
That also appears to be, so they have just, taken it. We'll, my brother is pointing out, we are removing the cost which was imposed on the appellant while you were there before the learned single judge. No cost to you.
My lords.
Be satisfied with that. Where will we send you back? We are not going, suppose we even say that. Otherwise also, with 1960 as your date of birth, you would have retired. 22. You would have retired in 2022.
2020, my lords.
2020. So
My
now
lord.
6 years have passed by. What do we do? Notionally, we put you there. We don't give you anything. Why do you want us to do that?
My lords, because I have been forced on early retirement by the illegal actions of the
So
state. My lords.
I mean, the cost imposed on you is absolutely incorrect. Not that we are giving you any concession. We don't find it to be justified. We are removing that. That should satisfy you.
My lords, I
think we have,
differ, my lords.
we have heard you with an open mind. I'm sure you would not doubt that. But now with this fact, we cannot.
My lords may kindly see page number 42A of my writ appeal, my lords.
You are way tenacious. Huh? We are happy to see this tenacity. Yes, page.
Page number 42A of my writ appeal, my lords. This is the typed copy and the original copy. My lords, this is the final interstate seniority list that was issued on 4th March 0403/2010, my lords. In this list, I am This list shows that I am the senior most officer under the PWD department, my lords. My lords, according to this, my date of birth has been clearly reflected as 18/10/1960 and my date of superannuation as 31/10/2020, my lords. Now, my lords, what the state respondents have
And
done
you were made to retire in 2017 only.
2017, my lords. That is 3 years prior to my actual date of superannuation, my lords. Now, my lords, considering the fact that the state respondents have initiated a departmental proceeding against me and serving me the memorandum of charge on 17/2/2017, and on the very same day that they had issued an order changing my date of birth, my lord. Now, all this boils down to the fact that the state respondents had no intention of giving me an opportunity of being heard, my lord. None, my lords. I was not given a single opportunity of being heard, my lord. And if my lords may allow me to rely on a judgment of the Supreme Court, my lords. A
Yes.
colleague of mine.
See, if your service tenure would have been left unexpired, say if this appeal we would have heard in 2018, 19, or even 20, we could have thought of doing something. But why do that?
My lords, this appeal had been filed in the year 2020.
Why don't you understand one thing? Now, let this be the last conversation between conversation between the court and the
My
council.
lord.
Look, if we say that you were wrongly made to retire in 2017, you should have been allowed to function till 2020. We'll have to stop there.
My lords.
For the reason that we can't ask you to be taken in service given another 3 years extension, because that with 1960 your date of birth, you retire by 2020. We
My
can't
lord.
even ask them to pay for those 3 years because wrongly you was sent out because you have not worked. We will not apply that principle. You're not a class 4 or class 3 employee, you're a class 1 government employee. So in
Well-
any view of the matter, your rights stand vindicated. We will say that the state of Mizoram should have acted more fairly, more prudently. They have not done it. But why this stricture unless it fetches you something? So what we do give you is to remove that cost, which if you have deposited, we'll have it returned. If you have not deposited, you shall not be under an obligation to.
My lords, may kindly bear with me and allow me to cite this judgment of the Supreme Court.
You have 5 more minutes. Yes, please.
My lords, a colleague of mine will pass over the copy of the judgment, my lords.
The young advocate, Shankar Lal.
My lords, 2022, volume 6, SCC 211, my lords, 211. The relevant portions are para 27, 28, and 29, my lords. Para 27, 28, and 29, my lords. May I read, my lords?
Yes.
We find that the action of the employer lacking in authority of law, in this case on 2 counts. First, it fails for not adhering to the principles of natural justice. The decision not to follow the service book recordal was taken without giving an opportunity of hearing to the appellant. The opportunity of hearing of the appellant also accrued because the employer themselves had proceeded on the basis that the letter dated.
Tell us one thing, the proceeding against you was initiated only for this. And what happened? Did it conclude?
My lords, it is the departmental proceeding stays unconcluded to this day, my lords. And on top of that, the inquiry report was not submitted by the inquiry officer as well, my lords.
Very well.
My lord, as such, from this judgment, para 29, if I may read para 29, my lords. The very reasoning on which an employee is not permitted to raise age correction plea at the fact end of his service to extend his tenure should also apply to the employer as well. It is the employer here who had proceeded on the basis of age of the appellant reflected in his service book during the latter's service tenure, and they ought not to be permitted to fall back on the Form B, which would curtail the VRS benefit of the appellant. My lords, in this case, it is not a matter where I have asked for alteration of my date of birth at the fag end of my career, my lord, nor during the course of my service, my lords. It is the state respondents who have proceeded to change my date of birth while the departmental proceeding itself was pending and remains pending to this day, my lords. Now the order changing my date of birth and the payslip which has been issued on 23/8/2017, they are unsustainable in law, my lords. How can they be sustained in law, my lords? While the departmental proceeding itself was not concluded and a reasonable opportunity of being heard was not provided to me, my lords. This is against the natural principles of justice, my lords, and a gross violation of my fundamental rights, my lords.
Already you have said that.
My lords, coming to my prayer, all we are asking for is that, yes, correct, I am no longer in service, my lords, but I have lost 3 precious years of the end of my career, my lords. Now, my lords, nothing can be done to reinstate me into service, my lords. But my lords may kindly consider those 3 years as regular service, which during which I should have been promoted to the topmost position as well, my lords, coming number 1 on the final interstate seniority list, my lords. My lords, this is
we would have readily done that, Mr. Silo. We would have readily done that. But for the fact that this bug has entered our mind, that it's a fact that your younger brother died, younger brother who retired was born in 1959.
My lords, the state respondents have stated that
Therefore, other
younger
facts are being
brother.
kept away. That is the whole thing. We can say that the state was not fair to you. Your employer was not fair to you. But what to do?
I must fairly state before
If
your
you had
lordships.
come with definite, whatever be the reason, if you had come with definite proof that Mr. So-and-so touted to be your brother is a fictitious person or not your brother, we would have understood. Or
My
your
lord,
cousin.
what the state respondents, if your lordships may kindly allow me, what the state respondents have
How
provided.
many times would you argue the same thing, Mr.? We
My
have
lord,
heard.
one last point, my lords. What the state respondents have provided is the date of birth of my birth certificate of my brother and the service records of my brother, my lords. This does not say that he is my younger brother, my lords.
No, we are asking you now at this stage. You
My
deny
lord.
that, we will do everything what we have in our hands. You
Absolutely,
deny that.
my lords. We are in denial of that, my lords.
So we should make that a statement on affidavit. We'll issue notice to him and we'll see what happens.
My lords.
Make a statement on affidavit that he is not my brother. Make a statement on the affidavit.
He is my brother, but he is not my younger brother, my lords.
Make that statement. No, make
My
that
lord.
statement. We will allow your prayer.
My lords.
Otherwise, we are convinced that it was the brainchild of the state.
I will do so, my lords.
Please.
My
take
lords.
them. The appellant is aggrieved by the judgment dated so-and-so, passed by a learned single judge of this court in WPC number so-and-so, whereby the alteration made in the date of birth of the appellant was at the instance of the state/employer was not interfered with. A Mizoram government servant joined service with his date of birth recorded as October 18, 1960 in his service book. This would have entitled him to remain in service till October 31, 2020. However, as it appears from records, in the year 2015, a departmental inquiry was initiated against him, suspecting that he had manipulated the date of birth in his service book to his advantage, while the fact was that his date of birth was October 10, 1957. This assumption was made on the grounds, namely, the appellant remaining in possession of the service book for about 6 years, which he returned only after multiple requests by the employer, and the state having found out that the appellant has a younger brother who also was in government service and who had retired because his date of birth was sometimes in the year 1959. Throughout the proceedings before the authorities and the learned single judge, there was no specific denial of the fact that the concerned person touted as his brother, as the brother of the appellant was not his brother. Otherwise, the learned counsel for the appellant has submitted that the entry in the service record, which stands corroborated with other documents like date of birth recorded in school certificates, birth records, indicate that the appellant was born on October 18, 1960. There ought not to have been any occasion for the employer/state to question that. It appears that during the departmental proceeding, a forensic examination of the service book was made, and it was reported that the entry with respect to date of birth as 18-10-1960 had been tampered with, as it could be perceived by the forensic expert that there were two inks used, two kinds of inks used, varying in the color content and luster. For curiosity, we examined the aforenoted page in the service book of the appellant, but did not find any tampering in the entry in the column of the date of birth. That apart, we have also taken into account that in the departmental inquiry, which remains inconclusive even today, no opportunity was given to the appellant to put up his case. However, what has struck us is that if his date of birth were to be accepted as 18-10-1960 as entered in his service book, he would not have been 21 years of age on the date when he entered the service on 10-3-81. The engineering service of Mizoram required any entrant in service to be of minimum 21 years. This therefore creates great doubts about the correctness of the assertion of the appellant. However, after having said that, we find there being no evidence whatsoever for the state to infer that state/employer to infer that the actual date of birth of the appellant would be 10th of October 1957. Where has this date come from is not intelligible to us, is not explicable to us. However, with the two facts remaining undisputed namely, the appellant would not have been 21 years of age with his date of birth as 18/10/1960 when he entered service, and which was a must, which was one of the essential eligibility requirements regarding age, and the younger brother of the appellant having retired as a government servant whose date of birth is recorded in the year 1957, we find ourselves unable to accede to the request of the appellant presently to restore his service even notionally till 2020, when he would have otherwise retired if his date of birth would not have been changed. At this stage, Mr. Silo, learned advocate for the appellant, submits that he is ready to swear an affidavit that the person who is touted as his younger brother with his date of birth in the year 1957 is not his brother at all, is not his younger brother. Let that affidavit be filed for the satisfaction of the appellant by the next date, re-notify on so and so.
Highly obliged, my lord.
एक सेकंड ऊपर में लिखा however on जहाँ लिखा है कि it is not explicable to us from where. However, from the statement of imputation of misconduct or misbehavior in support of the article of charge framed against the appellant, it is recorded that the date of birth of the appellant, that the 1957 date of birth of the appellant was entered in the guard file of PWD Secretariat. So stop. This at the time of his entry in the service. So stop. This also appears to be an apocryphal source for the state/employer. उसी जगह पर लिखना जहाँ पर वो apocryphal source for the state/employer to conclude that the appellant was born on 10/10/1957. उसके बाद then continue with that. All right, we have recorded everything what you have said.
31st March.
Highly obliged, my lord.
We have heard so and so. Yes, all right, Mr. Silo, you have done your job very well. Others,
I'm grateful for that, my
others
lord.
would not get any chance to argue. Mr. Goswami and Mr. Datta, I think we should take up your case whether you are interested in pursuing it.
My instruction is that, my lord, subsequent to the single bench order, my lord, there is a tender floated, my lord. Two participants were there, not the petitioner or the respondent.
He did not apply.
They did not apply, but my lord, now that there are some complaints by the local population, local public, my lord, so it has been decided to cancel the tender
Entire.
for that particular.
Good. And now when you open it, Mr. Datta also will participate.
No, in such a situation, my lord, if they want to withdraw it from that plea, what will happen, my lord, supposing
The money shall be refunded to you, otherwise.
Otherwise also. my lord,
Tenders are location specific, but that location we are not going because the superintendent has written to the government that it is difficult.
That's all right. He is worried about his 35 lakh.
That will be.
Apart from that, my lord, supposing your lordship interferes with the order of the single judge, my lord, then my position will come up. Then I have approved a right.
That we will not consider. No, we shall not do it at this moment. With everything gone, one tender process again having been finalized, remained unconclusive, and then complaints. We are not going to we are not going to give it a fresh lease of life of the earlier tender.
Can your lordship take it?
Are you satisfied with 35 lakhs to be returned with a permission with Nani, you take a call. What instruction are you? He's a young person.
My lord, can you take lordship tomorrow, my lord?
Tomorrow. All right. And which other matter? इसको कर देना tomorrow.
23, my lord. Item 23.
Item 23 is for what?
Not even direction for regulation.
What is 23?
Regulation of law faculty.
Oh, he is a big case. Anyway, we'll look here. For the paucity of time, this case could not be taken up. Effective hearing. Let this case come up for consideration under the same heading on, give a date in late March
31st
or
March.
sometimes in April.
2nd April.
Mr. Phukin,
25.
now pachyderms
Lord,
will,
it's like
pachyderms are safe with all this. We
May I
keep
just
it.
request a specific date, Milord, that's all I was.
We will give, we don't leave any petition undated. Any petition undated. देखिए इनके matter में लिखिए, let this matter come up for consideration under the same heading on. We fix it sometimes in April.
17th March, Milord.
March would be absolutely tight.
I'll take a date, Milord, then in April.
No, we are giving you a date.
2nd
We are
April.
giving you a date sometime, with the same, with that regular, that law professor's regularization case.
2nd.
All right, Mr. Datta, tomorrow take instructions and don't deter, don't prevaricate.
Yes.
Yeah.
Deeply obliged.